Good morning. I'm Councillor Brian Drayson, Chair of Rother District Council's Planning Committee, and I'd like to welcome you all to this month's meeting, which is the first of our new municipal year. The Planning Committee is required to consider all applications against both national and local planning policies, and where appropriate, the members use their personal knowledge and judgment to balance any apparent conflict in those policies for the benefit of the district as a whole. It should be noted that the Planning Committee is not a public meeting, but a meeting that the public are able to attend. Rother District Council has a public speaking scheme which allows members of the public and others to address the committee on a particular application. Full details of that scheme are available on the Rother District Council website. For those in the chamber this morning, there are no fire alarm tests scheduled for today, so in the event of an alarm, all persons in the chamber are asked to leave by the nearest fire exit and reassemble outside in the front car park. It is important that you remain there long enough to be accounted for so that members of the emergency services don't put their lives at risk unnecessarily searching for people that appear to be missing. We're joined in the chamber this morning by the following officers: Kemi Erifiviemi, the Development Manager, Felicity Thomas, Legal Advisor, Matthew Worsley, Development Manager, Team Leader, Michael Vladinu, Planning Officer, and helping with the meeting itself, we have the Clerk to the Committee, Secretary to the Committee, Julie Hollins, and Eleanor Drew, who is looking after our webcast. Just seeing who's joining us online, member-wise, or can I ask if either of the monitoring officers are online? I can't see them. No. Okay, thank you.
Councillor Mayor, I'll have to declare an interest later as well.
Thank you. Will you be speaking on that one, Carl? Councillor Mayor?
If it's not deferred, Chairman.
You obviously know something more than I do. Thank you. Right. Okie doke. So, now to the agenda. A reminder, please, to members in the chamber to make sure you turn your microphones on before speaking and, almost more importantly, turn it off when you've finished. We regularly have many people watching the webcast, and even though we can hear each other in the chamber, it is often not clear online. So please can I ask members to make every effort to speak clearly and directly into the microphone. And I know I can be one of the worst offenders on that one. So, agenda item 1, the minutes. Do I have your authority, please, to sign the minutes of the meeting of the Planning Committee held on the 18th of April and on the 20th of May as a correct record, please? Thank you. Thank you. Agenda item 2, do we have any apologies for absence, please, and any substitute members in attendance?
Yes, we've got apologies from Councillor Bayliss, Mrs Cook, Gordon and Stanger, and Councillor Tempe is standing in as substitute for Councillor Stanger.
Thank you. I believe there's no additional agenda items, and item 4, none of the applications have been withdrawn. Agenda item 5, disclosure of interests and dispensations. To receive any disclosures by members of a disclosable pecuniary interests and other registrable and non-registrable interests in matters on the agenda. The nature of any such interest and details of any dispensations obtained. Also, if any member considers themselves to be predetermined on any matter coming before the committee today, they should declare it and leave the chamber at the appropriate time. Councillor Timpe.
Thank you, Chair. Bexhill Town Councillor.
Thank you. Is there an agenda item that's directly related to?
Seaborn.
Oh, yes, of course. Thank you. Councillor Byrne.
Member of Bexhill Town Council.
Is it also agenda item 9?
It is indeed.
Thank you. So, taking the hint, I should also declare that I'm a member of Bexhill Town Council and might have an interest in agenda item 9, Seabourn Road. Councillor Maynard.
Thank you, Chairman. Just the agenda item relating to Westfield. There is obviously East Sussex County Council will be mentioned, so I'll declare a personal interest as an executive member of East Sussex County Council.
Thank you. I think that's agenda item 8, isn't it? Yes. Thank you. Right, and members are reminded to repeat that declaration immediately prior to the commencement of that agenda item. Now on to agenda item 6, planning applications. That report, the final page of the report, shows the applications being considered by the committee today. The members of the Planning Committee understand that planning matters can be very emotive, especially for those directly affected by the outcome. Nevertheless, I would like to ask everyone within the chamber to remain calm and courteous throughout the meeting. Thank you. Right, agenda item 7, application RR/2022/2791/P, Fir Tree Cottage, land adjacent to Netherfield Hill Battle. The application is for change of use of the land from agricultural use to mixed use of agricultural and the stationing of caravans for residential purposes for a temporary period of 3 years, part retrospective. This application previously came before the committee on the 22nd of June 2023 and planning permission was granted for a temporary period of 3 years. The decision notice was issued on the 28th of June 2023. An application was made for judicial review seeking an order quashing the decision of the planning authority to grant planning permission for the development. By consent, an order was made by the court on the 28th of February 2024, quashing the planning commission and remitting the matter to the council for redetermination. This is not a new application as such, but the planning committee must consider it afresh as directed by the consent order. Members like me who took part in that meeting are reminded again that we must approach today's discussion and vote in the same way that we do for all applications that come before us, that is, without any prejudgment and with an open mind. The officer presenting this is Matthew Worsley. If you please, Matt.
Thank you, Chair. As explained by the Chair, this application was previously reported to the 22nd of June 2023 Planning Committee meeting with an officer recommendation for approval which members resolved to grant planning permission for. Subsequently, that decision was subject to judicial review where one of the grounds of challenge was agreed by all parties. The High Court has quashed that decision and sent it back to Rother District Council for redetermination. The previous report and recommendation have been updated to take into account updates in policy and comments received from members of the public. The proposal follows the refusal of a 2020 planning application and subsequent enforcement notice, which was upheld in November 2021 for the material change of use of the land from agricultural use to a mixed use of agriculture and the stationing of caravans for residential purposes, together with associated works. As of November 2022, up until the present, the unauthorised use remains, which is in breach of the enforcement notice. The proposed development differs to the unauthorised use in that the caravans would be moved further away from the ancient woodland adjoining the west boundary of the site, with a separation of approximately 25 metres detailed on the submitted plans, which will be shown later. A parking area would remain around 15 metres from the boundary with the ancient woodland. In the area between the parking area and the ancient woodland, the proposed block plan shows a meadow would be planted together with a post and rail fence and mixed native hedge on the edge of the parking area. Further development has taken place between when the planning permission was issued in June 2023 and the quashing of that decision on the 28th of February 2024. Those of you on site on Tuesday would have noticed, the caravans have been moved away from the ancient woodland and more hard standing has been laid. The application site lies to the south side of Netherfield Hill. It is positioned between Fir Tree Cottage to the east, which is the property you can see to the right-hand side of the site plan on the screen, and Ashes Wood to the west, which is designated as ancient woodland and is also covered by a right to roam. There is a public right-of-way around 200 metres east of the site, linking Netherfield Hill to Ashes Wood to the south. The site is located within the countryside, outside of a recognised development boundary, and is within the High Weald National Landscape. There are some aerial photography shots to show you in the presentation, starting with May 2018, which shows the previous use of the site. It included an L-shaped stable block and other buildings along the boundary. That stable block was granted around 20 years ago. Not for a specific equestrian use. There was no change of use involved back then, so the agricultural use stayed. April 2020, around the time the occupiers moved into the site, you can see here caravans, that the stable block had been removed at this time. Some of the buildings shown previously remain on the boundary. August 2022, you can see that there's a caravan on the site of the hard standing where the stable block once was, and there's another static caravan to the south, the beigey coloured roof, with what appears to be a touring caravan in between. This was the previous layout of the site. It showed a mobile home on the static mobile on the old stable base, with a further static caravan to the south. And then we have the proposed block plan showing the two mobile homes moved further east, with the area closest to the ancient woodland cleared and planted as meadow with native hedging. The site is occupied by two families. One plot is occupied by a female adult with 5 dependent children, and the second plot is occupied by a female adult and 2 adult sons. The relevant policy considerations and main issues are set out in full in the officer's report. At section 8.6.3, it is explained that to support the Council's new local plan, Rother has worked with the East Sussex local authorities to commission a joint gypsy traveller and travelling show people accommodation needs assessment for the study period between 2021 and 2040. This identifies that 28 additional pitches for gypsies and travellers are needed in Rother over that period, including 14 between 2021 and 2026. 5 pitches have since been delivered, bringing the total need down to 23, or 9 to 2026. Therefore, whilst the Council can currently demonstrate a deliverable 5-year supply of pitches in line with the Rother local plan core strategy targets, the publication of the new accommodation needs assessment strengthens the position that the locally set targets contained within the core strategy are out of date and is a material consideration. As explained within the report, the proposed development would result in harm to the landscape and scenic beauty of the High Weald National Landscape, which must be given great weight. The unsustainable location of the site also attracts moderate weight. These findings are the same as those from the inspector who upheld the enforcement appeal previously. Those issues bring the development into conflict with the adopted development plan policies, so those in the core strategy, DASA and neighbourhood plan. In addition, intentional unauthorised development has taken place, although for the reasons explained within the officer's report, its officer's opinion, this only carries limited weight against the scheme. However, officers have given significant weight in favour of the development due to the current lack of local provision of gypsy and traveller sites. There are also no alternative accommodation for the occupiers to move to, which is another significant factor in favour of the development.
Point of order. This is not an application for a gypsy site, so to continue referring to it as a gypsy application misleads everybody. There should be no reference to their status, just as there should be no reference to their status were they to be Muslims or Catholics or black or otherwise.
I think just in terms of legality, I've interpreted the officer making reference to those issues because they are live issues in the case. They've been live issues indeed in the enforcement appeal and of course in the judicial review. So that there are gypsy and traveller policy factors that must be taken into account in relation to this application. So I haven't noticed any particular reference to this as a gypsy and traveller site, more to this application concerning gypsy and traveller policy issues that have arisen in the application process. Forgive me if I missed any other reference, but I haven't understood it to be any kind of pejorative reference made to the gypsy and traveller community, only that this particular application involves those issues.
I don't see why, but in any case, it will likely be grounds for appeal. So, anyway, thank you.
Thank you, Councillor Ganley. Thank you for listening. Matt.
Yeah, I'm just finding my place. Okay. On top of the things weighing in favour of the development are the personal circumstances of the occupier of the site, including the best interests of the children, which attract significant weight. Overall, there is conflict between the issues weighing for and against the development, which includes the development being contrary to policies contained within the development plan. The main factor against the development is the harm to the landscape and scenic beauty of the High Weald National Landscape. In time, once a new local plan is adopted with gypsy and traveller allocations, there is a real possibility of more suitable alternative sites being available. With this in mind, it is important to consider the proposal is for a temporary 3-year period. Given the significant material considerations highlighted weighing in favour of the proposal, in the circumstances and on balance, officers recommend that the application should be supported. Thank you.
Thank you, Mr. Worsley. We have 2 registered speakers on this agenda item today. Each speaker may speak for no more than 5 minutes based on their previous written submissions. If they are not allowed to introduce new information at this stage on the proceedings, and when they finish, members of the committee may ask them questions to clarify anything they've said in their presentation. To ensure fairness between the speakers, I will interrupt anyone who is still speaking at the 5-minute mark. And the first speaker is the applicant in this case, Susie Smith. Thank you. Sorry? Sorry, one moment. Yes, I got it wrong. Sorry. We have the objector first, Mr. Bernard Brown.
Good morning. I'm Bernard Brown. I'm speaking on behalf of the residents at Netherfield who are members of a group called Rowden, which is Residents Against Unauthorised Development in Netherfield. In February 2020, the applicant purchased this site, knowing all previous planning applications had been refused. Contrary to legislation then prevailing, they illegally moved onto the site, not as claimed from the roadside in the COVID pandemic, but planned in advance from secured registered places of residence. They chose to move into the National Landscape Area. To do so was a deliberate disregard of planning law and policy. As an exchange with the neighbour explained their approach, we do not do planning. This site is part of the National Landscape, an incredibly important asset. The officer's report quite clearly sets out the site fails to meet many, if not all, of the national planning policies, the local plan and the neighbourhood plan. This is not an academic question. As your site visit, you will have seen the extent of the incursion into the protected nature of the land. You saw the extent of the works which are completely incompatible with the temporary nature recommended for approval. You saw many signs of inappropriate development. But what you did not see was the poor state of the site just a few weeks ago, with dumped detritus and plant and machinery scattered over the site. The poor condition of the site is not hearsay, it is witnessed through pictures included in my written objection, and they are on the planning portal. I hope you will take a look now before you reach your decision. Do not be misled by the massive clear-up undertaken specifically for your visit. Destruction and desperation of the natural landscape was prevalent. I trust the legal representation made on behalf of the Netherfield residents has been disseminated to you. It is clear that on the grounds which I was granted permission to proceed to judicial review have been largely ignored in the officer's report. It was not just a simple, if unforgivable, administrative error. This committee is now aware of the view of leading counsel that the officer's report is legally flawed with regard to environmental considerations. Insufficient consideration has been given to the status of the ancient woodland, protected species or biodiversity, all contrary to the climate emergency and environmental policies of Rother Council. The Woodlands Trust guidance on buffer separation of 50 metres from the ancient woodland is simply ignored, as is the Inspector at Appeals' general comments concerning unacceptable disruption just by the existence of the site. A solid legal challenge has been identified on the weight given to the best interests of the child. It is a combination of factors which lead to the conclusion that any decision to grant consent on these grounds would be unlawful. I hope you are to be appropriately advised on this matter today, and if not, why not? This committee has to consider planning law and making planning judgments. Does it not send out the wrong message to all citizens if those who flout the rules, we all need to follow the rules, can clearly benefit by their actions? Being a traveller should not mean that the rules do not apply. For clarity, the applicants have been on the site unlawfully for 4 years. Another 3 years would mean their temporary use would be for at least 7 years. You have seen from the site there is nothing to suggest they would just leave at the end of that period. Their actions suggest the exact opposite. They should not benefit from their unlawful actions just because there is a shortage of traveller sites. Since the consent granted in June 2023, the applicant has made no or little attempt to meet any of the conditions then imposed. I ask the committee to consider in particular paragraph 8.13.2, which is to do with the unauthorised occupation. And it says, nevertheless, in 2020 there was intentional unauthorised development, but given that this was at the time of the COVID-19 lockdown and the overall circumstances, including the personal needs of the occupier of the site, this carries little weight against the development. Frankly, the misleading inaccuracy of this paragraph is breathtaking. The site was acquired before the COVID pandemic occurred, before the COVID-19 lockdown. The move was planned before COVID. They moved onto the site when such movement was illegal. They moved from secure residential settings out of the area. They moved into the national landscape. This intentional unauthorised development was designed to ignore planning law. COVID-19 had nothing to do with it, and great weight should be given against the development on these grounds.
Thank you, Mr. Brown.
Thank you.
Thank you. Just one moment. Mr. Brown, one moment. Members might want to ask you some questions. So, any questions for Mr. Brown, please? No. So, thank you, Mr. Brown. And now I have got it right. It's now the applicant, Susie Smith. If you could make your way to the desk. Thank you. Thank you. Can you see the button with the... Yeah, if you'd like to introduce yourself, please, and then fire away. Thank you.
My name is Susan Smith, and I live at the property what everyone's talking about. We're not there to upset neighbours or upset the people of Battle. We're there because we've got no warehouse to go. I have to say this as well before it runs out. No one house here would like it if they had a drone going over their property taking pictures where there is children, it could mean all sorts of things. No one would like that if we were doing that in their gardens. We're not there to upset people. We're there to just have a place to live at the moment. And whatever the council says, we do. We don't go against the council. And I think the council has got a hard job because there is no properties for traveller sites. And that is all I've got to say, to hear the truth, because I'm very, very upset for what's been said today, because my place is clean and the council's been there many times and it's always been clean. It's not a state at all. There's more state places there than what ours is. Thank you.
Thank you. Anyone got any questions for Susan? Councillor Ganley.
Thank you, Chairman. Hello, Mr. Smith. Thank you for your presentation. Were you living, prior to moving to this site, were you living in a council house or in a...
We're not allowed to live on the roads anymore. So we had to get on somewhere, especially with the pandemic. It wasn't done deliberately. It was because of arguments between families as well.
I'm not quite sure what that is, but so you were not living in a council house before moving into this, nor were you living in a, what was it, a secure travellers site operated by... You were not?
No.
Thank you very much.
Thank you.
Thank you. Councillor Mrs. Merrill.
Hello. Just following on from that, I see that you were registered at a surgery more than 30 miles away. So from your caravan on the side of the road, you were able to register for health at a local surgery, were you? And how come? Because
I've got a daughter what's in a house, and I use her address for my doctors and stuff like that.
Right. So are you registered with a local surgery now?
No, it's still at my daughter's because it's not a proper property, is it? We're only there temporary.
Thank you. Councillor Gray.
Mrs. Smith, sorry, can I just ask you about the children? Are you the mother of the children who are home educated?
No. I'm the mother of the two boys what's got learning difficulties.
Can I just ask you, are the children home educated for a special reason?
Yeah, they've got special needs. Some of them.
What I wanted to know was, if you lived nearer to a school, would the children attend a school?
That's not up to me to say. It's down to their mum, which is not here now.
And, sorry, can I also ask, who does the home educating?
Again, that's down to their mum to say that, because I'm not their mum.
Okay, thank you very much.
Thank you. Any other questions? No? Thank you, Mrs. Smith.
Thank you.
I just wonder if Councillor Byrne is online. I wasn't sure. No, so there's no ward councillors. And Councillor Field didn't. Okay, thank you. Good. So in that case, it's now question times for the officer, please. If anyone's got any questions for the officer. Mrs. Barnes and then Councillor Ganley.
Thank you, Chairman. A couple of pages 22 and 23. There's a claim made by the officer that the proposed development would not adversely impact on the ancient woodland. I would like to know what evidence there is for putting that, because it's a big claim, and I just wondered how he could possibly say that it would not adversely impact.
Thank you, Councillor. Refer back to the aerial photography I showed in the presentation, and specifically the 2018 one showing the L-shaped stable block and other buildings next to the ancient woodland. That was in close proximity to the woodland, within 15 metres, which is against current guidance from Natural England and the Forestry Commission. The proposal before you, shown on the current block plan, moves and clears all the development from that buffer area. It is proposing to plant a meadow there with native hedges, and compared to the old situation, it would be an improvement to that.
Chairman, can I come back on that? I mean, everything that's happened on this site is contrary to how it was before the two families moved there. So planting a hedge is not, I would have thought, a considerable improvement on what was there before, because it is actually to mitigate the damage that has already been done. I mean, ancient woodland is something that needs to be protected. It needs to be set in its own setting. The meadow needs to be, as one would have expected a meadow to look in an area of outstanding natural beauty or landscape or whatever it is. Do you not agree that they've already impacted on that woodland by its setting, by the way that moving the caravan around is fine, but it's the impact on what was ancient woodland in its correct place in the landscape. So I don't see how the ancient woodland can not be affected, even if you move the caravans around.
My point was that there was already development on the site and activity, and the stable block was a lot closer to the ancient woodland. What they're proposing now is further away. This 15-metre buffer is in line with national guidance. That's the recommended minimum buffer to ancient woodland to provide it with some level of protection. We impose that guidance. We've imposed it on many other developments, larger housing developments across the district where it's near ancient woodlands. So, in comparison, I don't see any difference.
I think, Chairman, what I'm trying to say is that a claim has been made without any backup evidence. Similarly, the claim further down, which is there are no adverse impacts on the living conditions of Fir Tree Cottage. Do we know that?
I mean, that is, as case officer, that's my assessment, that's my professional advice to you.
You haven't talked to them?
I've taken account of all the local residents' concerns in terms of separation and general activity from two residential units. The separation is far greater than you would see on an estate where houses are next to each other. It's two residential units. When you're talking about a residential use next to another residential use, it's Yeah, the separation is fine. I haven't seen any evidence to demonstrate the neighbours' living conditions are adversely impacted.
But sorry, Chairman, if I may just literally pursue this point. We know that previously an application for a house on that site was turned down because of primarily because of the AONB, and yet somehow or another this is a totally different ballgame. I'm sorry, I'm trying to get my head around the fact that we have got to make this a special case, a special need, and I'm failing miserably right at this moment.
Thank you, Councillor Barnes. I don't think this answer. I think I'll go to Felicity later on that when she had time to come back on that. Thank you. One moment, Councillor Mear. It's Councillor Ganley, then Councillor Gray, then you. Councillor Ganley.
Thank you, Chairman. Matthew, you use the best interests of the children essentially to justify your recommendation to this committee to approve the application. Am I correct?
It's part of the reasoning.
Part of the reason.
Correct.
I'll come back to that in a minute. The best interest, nobody would disagree that the planning decision should be made with the best interests of children in mind. However, the children involved do not have any educational or medical needs, or at least no evidence has been provided to suggest that they have educational or medical needs. The 5 children are being home educated, which is something that can be done anywhere. So where is your evidence that there are special needs for these children? Or that the interests of the children would be damaged by refusing this application?
As set out within the report, as part of the application, we did receive personal sensitive information about the occupiers of the site. Some of that relates to the children. But for data protection reasons, we can't share the specific information. So there is evidence there to back up the claims. It may be that the needs of the children could be met on a different site. The issue we've got is there aren't any other sites, and if they're not permitted to stay till the council find additional sites through the new local plan process, there's a real risk that they wouldn't have a permanent place to stay or a safe place to stay. So at this time, our advice is that it is in the children's best interest to stay on this site temporarily.
So, if I understand it correctly, you're asking us to approve an application based on information that we're not allowed to know.
It's been summarised within the report, but for data protection reasons, we can't get into the specifics of it.
I understand the data protection EU-dictated rule about data protection. However, I think it's what I said earlier is quite accurate. Sorry, I'll allow Kemi to finish speaking to you. I repeat what I said earlier. You're asking us to approve an application on the basis of information which we're not allowed to know. Is that correct? Yeah. Thank you. Who said yes? I think it was Kemi who said yes, was it? No? Matthew?
Five. Nobody up this end said yes.
Could I ask Felicity to perhaps provide, is it appropriate to provide some advice on that? Or?
Yes.
Is that okay? Thank you.
I understand the question to be essentially that what you seem to be asking is whether the classification of the occupants of the site essentially overrides other planning considerations. Is that a fair understanding?
The classification. Could you explain that? The classification.
No, I'm asking for clarification of the question. Are you asking?
I'm asking if I'm correct in thinking that we are asked to approve the application on the grounds of information which we're not allowed to know.
I think this is addressed in the report, and you're looking at 8.12. In particular, if you look at 8.12, this is the whole section of the report which deals with the personal circumstances, human rights, and the best interests of the children. And the position in the MPPF is set out at 8.12.1, and then the planning guidance at 8.12.2. And then at 8.12.3, that is where the discussion of the factors of the particular applicants in this case is brought in. And we are told there at 8.12.4, through the consideration of the previous planning application, together with additional confidential information received as part of the current application, and then it goes on to summarise the factors that have been brought up from that confidential information. So it is right that there is confidential information that concerns the individuals on site, that is material to the application. But in terms of the decision you're being asked to make, that information, the relevant parts of it, are summarised in these paragraphs. So you're at 8.12.4 down to 8.12.10. So that is where the officer summarises the planning impact of the confidential information that has arisen on this part of the application. In other words, that has arisen since the original application was made. So I think your question to me, are we being asked to, or to the committee rather, are we being asked to make a decision on information we're not allowed to know? Not really. The planning impact of the confidential information is summarised in the report. So any planning relevance of the personal information that's been supplied is summarised in the report.
If I'm correct, you were referring in fact to the two adult sons and two of the children living on the site who have significant medical conditions and learning difficulties. I'm not sure who have these significant medical conditions and learning difficulties, whether it is the two adult sons or two of the children. Could you clarify that?
I'm not sure that much detail is relevant. We have the summary of the conditions, the personal circumstances. Who has which problem, I don't think is relevant. You've had the summary, and I think Felicity's given you a very good answer on...
With respect, Chairman, it is relevant because the application is recommended for approval based on children's condition, not adult children, but children under the age of 18. So it is relevant.
Councillor, it's quite right that the material's relevant. What is being said is that all material that's relevant to the planning considerations is summarised in the report. But if the members find that that is has not provided enough information in order to be able to make a decision, then of course the committee is at liberty to defer in order to see if there is any other information which can be elicited, which is not confidential to the applicants.
Or refuse.
Well, I think I don't think not having enough information would be a ground for refusal, as it would found a ground for deferral for this to see if there could be further information or further clarification about the personal circumstances clarified or supplied by the officers.
I understand. Thank you.
I'm grateful.
Thank you, Felicity. Councillor Gray.
Thank you, Chair. Matt, can I ask you a couple of questions? Sorry. On page 27, paragraph 5, you got it? You say, within 2 months of the date of the decision, a scheme for the provision of foul and surface water drainage works shall be submitted to and approved in writing by the local planning authority. So my question is, what is the current arrangement for sewage? And also, do they have mains water and electricity? And if not, how do they manage? Thank you.
So, in terms of foul sewage, there is a packaged treatment plant on site, but we haven't got the full details of that. Surface water, again, we haven't got full details of that, hence why it's a condition. Electricity, there is an electricity supply to the site. Water, I assume there is, but I don't know for sure. Okay.
Councillor Mear.
Chair, I have, I think it's 5 questions. I don't know if Matthew might like to take them one at a time. Might be easiest. The first one is, I was here on the previous occasion and I voted, and of course I'm looking for any reasons, any differences between the applications and the circumstances now, which might cause me to change my mind and vote in a different way. So we've had a judicial review, and you referred to new policies. Is there anything in that judicial review or in the new policies which is different, which I should be taking into account, which is different from the considerations I took into account on the previous occasion?
I mean, the judicial review, the decision was quashed on a procedural matter.
So Mr. Brown disputed that, so perhaps you could cover it, or someone could cover it.
Well, there was a ground that was agreed by.
I wonder if I can help to clarify. The judicial review was compromised by agreement that a particular ground, and I'm very aware that we have the applicant at the back of the room, so I know he'll correct me. But essentially what was agreed was that there had been a defect in the advertisement of the application, and therefore on that basis the authority agreed that that should have to be redone. So the order itself is that the claim by consent was compromised on ground 1B, and that grounds 1A, 2 or 3 had not been determined. Now, there's a very important distinction. The grounds were given permission That does not mean that they've been judged. It just means they've been given permission to go forward for consideration. But before they've been determined, the matter has been agreed between the parties that the advertisement point was a defect, and on that basis alone, that initial decision should have been quashed and it should be retaken. And that's exactly what's happened. It's been quashed, and this is the process of retaking. So the other grounds that went forward were never determined by the court. So neither party can say that any of those grounds were either right or wrong, either the applicant or the council. They simply didn't reach the judges. What happened was it was curtailed at the point that the local authority agreed the advertisement hadn't been done quite correctly and that should be redone.
Thank you. And I would say I don't see anything in the advertising of this which would make any difference to what I'm considering today, which brings us on to the changes in policy. Mr. Worsley, if you would.
I think the key thing is the national planning policy for traveller sites and the definition of gypsies and travellers. And apart from that, there's no change in policy.
Excuse me. So, moving to my next question. Last time we granted a temporary permission for 3 years. We're now a year into that. Should we be considering granting, if we so chose, to grant permission for 2 years rather than 3 to keep it in line with what was decided previously? Or is the situation perhaps with the delivery of the site such that it is necessary to give 3 years, in effect an additional year?
The temporary 3-year permission was what was applied for, and a year ago that was in line with the new local plan timetable. Whether it could be varied.
Thank you, Chairman. In terms of what you're asking is whether or not we need to amend the description itself. The description can stay, but in terms of the condition still gives it until 2027, which still keeps it within that lifespan of the original permission that was quashed. Yeah, essentially, because we've still got the conditions as per previous recommendations. So the condition 1 says that they need to vacate the premises by 2027, and that was what was agreed previously, I believe, and so that still stays.
What we granted before would have been 3 years from last year.
But the condition puts it to 2027, so we are still in the same.
It would have been 2026, surely.
So I think the officer's recommendation is to grant a 3-year permission in line with what was proposed. Your question is, could that be lessened to 2 years? I think if that was in line with the new local plan timetable, that would be justified. But we would need to be satisfied that it's realistic that the new local plan will be adopted by that time with the allocations for new gypsy and traveller sites.
I think then...
One moment, I'll just clarify. I've just looked up the original, and in fact it was to be removed before the 22nd of June 2026. So this new one is a 3-year one, not a 2-year one. that goes to 2027.
Just for clarification, Chairman, just for clarification, I think I was looking at the conditions of the current report on the basis that we're bringing back the original report. So apologies for mixing that up.
One moment, I think Councillor Mears is still on his, or is it relevant to this point?
Yeah, sorry. And
okay.
We can impose that original June 2026 condition onto it. Yeah.
Yes, Chair. Chair, it's not. I mustn't try to go back into your chair, and I have no wish to do so. But perhaps we might, discuss this when we have our general discussion. On the previous occasion, a councillor proposed that permission be granted for 2 years rather than 3, and that was rejected. I think quite rightly at the time. And it might be that some other councillor might make a similar proposition on this occasion. I don't know, but I think we've had our answer from officers. I'm not quite sure yet, though, whether the delivery of the new local plan will be sufficient to enable these individuals to find another site within 2 years.
Who knows about the local plan? Thank you. Did you have... I've lost track. You up to 4 or 5?
I think that was the second. When I was present at the site visit, and I think to the south or southwest of the fence, there were structures which might have been chicken sheds, I don't know. Do those structures form any part of this planning application?
No.
Outside the red line?
Just going to bring that map again.
Correct, outside of the red line.
Thank you. There's then a matter which I have raised with you informally. On the previous occasion, the committee added a condition as to the size of caravans on the site, which I think is prudent in the interests of certainty as to what is to be allowed there. And I'm sure that the lawyer is probably going to tell me that the definitions from the Caravans Acts in the 1960s don't actually apply in these circumstances. But, one should perhaps be aware that the statutory definition of caravans in relation to caravan sites, which this is not, do allow caravans up to 20 metres long, which, we do want to be sure that we're not going to be permitting anything of that sort, rather confine it to what is approximately there on the site at the moment, which I think is the intention of the applicant. I would ask for that. You have no objection to that condition being added, if we saw fit.
The previous temporary permission that was granted, members of that planning committee chose to impose that additional condition about caravan size, and there was a planning reason for it, so that could be considered.
And the last one is, this is a retrospective application. How much or how little weight should we give to the fact that it's retrospective?
It's not, no weight from an officer's perspective. The issue of intentional unauthorised development is covered in the report. There were previous questions on that. So,
thank you. Those are all the questions I had, Chair.
Thank you. Now, I'm just going to ask Mr. Brown, because Felicity almost invited him to say something. I'm going to ask Bernard to come back to the table, but Mr. Brown, can you just confine it to whatever Felicity said and not use it as an opportunity to finish your unfinished? Thank you.
Thank you. Yeah. On the question of judicial review, there were several grounds. Before you can get to actually have the judicial review, a High Court judge has to review the grounds which you submit. that stage determines whether the grounds are valid for consideration or not valid for consideration. And in all cases, I think there were 4 grounds that were used, one of which was a little bit low level, saying that I had no interest in the case, were all dismissed as being, the opposition to them as being invalid. So all the grounds were proven to be valid for consideration. The nature of judicial review proceedings are if that one ground is consented to, then the whole thing stops because it's quashed at that point. If the judge at that time had decided that the grounds that we had put forward did not have merit, not they had been determined, but they did not have merit, then they would have been struck out, and they weren't. So those grounds were considered to have merit to go forward. It was then that the council decided to concede on the one point, the very technical point, and so the whole thing was dropped. The normal procedure, I would say, following on from that, is that when it comes back for reconsideration, those grounds which were considered to have merit for consideration should be readdressed. And the big complaint that I would have is that they have not been readdressed. And that counts Councillor Mears' point.
Thank you, Mr. Brown. Thank you.
As far as I'm aware, Mr. Brown, we are completely on the same page in that all your grounds were given permission. That is exactly what you say. They were found to raise valid points of law. But they did not go forward for the judges to make a decision on them. But you're quite right that all your grounds were given permission, that they raised valid points of law, and that were the case to proceed, they would and should have been considered by the judges. Of course, that procedure was interrupted because everybody agreed that the first ground meant that matters should be re-advertised. But it's quite right that what you say, that the grounds were given permission, were considered to raise valid points of law. And as you say, obviously a wise local authority in reconsidering the application would of course take those points that were given permission into account. I think there might be a broader question you're raising about whether, in your view, that's been done, and I understand that your view is that that hasn't been done adequately. I'm grateful, and I think you raised that in the letter to the council of a couple of days ago. Is that right? I'm grateful. Has there been a response to that?
So the question was, has there been a response to that? And the answer is probably there hasn't been, as far as we know. One moment.
I haven't seen that. Was it a response to just saying that you are...
I shall come to you in a moment, Councillor Ganley. You are next, but we're just looking to see if Felicity had the response, and of course if she's had the response, none of us have.
There wasn't a response, it was just that Felicity can address some of the points.
Oh, we've seen Mr. Brown's, but we've not necessarily seen the response from our legal department. I have to say we haven't officially had the letter, but Mr. Brown has sent the letter to everyone. Late.
Have you had a response? Right.
He had an acknowledgement from me, but he hasn't had a response.
Right. I don't think that's been done.
I think I'm going to go to Councillor Ganley because I think I know what may be coming on this and a couple of other points that were made earlier. Councillor Ganley, you wanted to say something?
Thank you, Chairman. Paragraph 8, page 27, condition 8, should the application be approved. Condition 8 says that the site shall not be occupied by any persons other than gypsies and travellers. Why?
That has been amended. You should have had that circulation from Trish.
Triggle.
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 Triggle. You should have had that. That came out late yesterday with the changing of that paragraph.
You know what it said?
It includes names of the individuals more so than that one, I think. Have you got it to hand?
Well, further down that paragraph.
Yeah, one moment. Kemi's got it up. I haven't.
So. It's all deleted except the last bit. Is it?
Thank you, Chairman. From advice from our legal officer, he wanted us to tighten the condition to the occupiers only,
yes,
and also for that temporary period. So I have, because I was out of the office yesterday, so I've just more or less picked all of this up this morning.
Right.
We have got, do you want me to read it out?
Okay for me to read it out? Well, does it simply delete the first sentence, which is most of the paragraph, relieving the occupation of a site shall only be restricted to Ms. Sherry McAllister and Ms. Susan Smith and their dependents? Is that basically what it says?
Yeah, yes, and it also includes the temporary period. So the use hereby permitted shall be occupied only by Ms. Sherry McAllister and Ms. Susan Smith and their dependents, and the site vacated on or before, if members want to go back to the 2 years, 22nd June 2026, or period during which the site is occupied by them, whichever is shorter. When the site, so it just sort of tightens it so that they have to vacate the site. So it's sort of tied in with condition 1. So condition 8 and 1 sort of tie together properly.
Right. If I may say, the officer continues in the officer's report. There is a frequent reference to gypsies and travellers. And I just do not understand why that should be the case when it is not an application for a gypsy or traveller site.
Maybe I can sort of make a bit of, maybe offer some clarification in terms of that. Usually the permissions are tied to the land.
Yeah.
We are asking you to make an exception in this case and just attach it to the person and the occupier for that period. Right. And once they go, that use goes away with them, so it doesn't stay on the land, and that is the reason why we are asking for this exceptional circumstance for it to be temporary and to these occupants only, so it doesn't transfer to anybody else.
That wasn't actually addressing my point that I just made, and that is the continued reference to gypsies and travellers. If you just refer to the names of the people, then you're not referring to gypsies or travellers. So that was my point. Why continually refer to gypsies and travellers when the status of the applicant is irrelevant, just as it would be if there were Hindustani, black, or green, or blue?
I don't think it is irrelevant. We'll come to that in a minute, but I've got 3 councillors now wishing to speak. I think Councillor
All right, I'll leave it to
Groner wanted to, and then Councillor Groner. Sorry. Defer to Councillor Mear.
I seem to remember something about this in our discussions on the previous occasion. I think we suggested a form of wording, something like the named individuals being gypsies or travellers, so that it made it clear that that's why they were the named people.
I don't think so, but I'll go to Councillor Byrne and then Councillor Timpey. Councillor Byrne, I think we're talking about protected characteristics of personal of the applicant. So it has a relevance because it potentially trumps everything else.
Well, indeed, we are referring to their characteristics, but were they Catholics? Would you refer to them as such? Were they?
If it was absolutely relevant and it was a protected characteristic, yes, but I can't. We can't have the law that we wish to have. That there is a specific protected characteristic of.
Okay. Well, we beg to differ.
Thank you, Chair. Thank you, Chair. I'm trying to put together the various points that have been made and make sure I've got the balance correct. This application is not made in the name of gypsy or traveller families. It is purely an application for those particular people to remain where they are. However, if we refuse, those people then become homeless and could claim accommodation as gypsy or travellers on another site. However, we don't have another site, and we won't have another site until we get our local plan. So that's the 3 years. So it is human rights come into play if we evict the people from this particular site because there's nowhere for them to go. But in 3 years' time, that would not be the case because there would be somewhere for them to go, and that somewhere rests on them being of gypsy and traveller descent. Am I correct in that summarisation?
No, there's no guarantee.
One moment. I don't know. You can give the best answer to that one because.
That we will have a gypsy sites found in the next few years.
There's no guarantee, but that is our intention.
As there wasn't last time.
As there wasn't last time, indeed.
Yeah. So, Councillor Timpey.
Yeah, thank you, Chair. In that paragraph, condition 8, page 27, the reason is quite clear. It says the proposed development is only acceptable on a temporary 3-year basis due to the personal circumstances of the applicant and their way of life, which mean that they meet the definition of a gypsy or traveller, in inverted commas. I find this whole discussion really quite offensive in some instances from certain councillors. It's quite clear the officers have made a case. They've put and what I find is people actually don't read the report because all the information is in there, and there is significant weight to certain factors, and even though it's against policy or whatever, and we have to look at this as an exceptional case. And I'm not sure that we're actually being quite unbiased in considering it as such. That's my personal opinion. Thank you.
Thank you. I'm going to say something now. I try not to, as chair, to be front and centre. I'm going to ask, or then I will move if necessary, if anyone's prepared to move deferral on this based on the 3 points that Mr. Brown made that don't seem to have been built up by Felicity, that don't seem to have been covered in the report, and the fact that, yes, some of the comments are sort of unsavoury. Sorry, but I think Matthew is not happy with what I just said. Yes, sorry. that was, they have been covered, but we may not be satisfied that they've been covered enough, and we have not seen officially Mr. Brown's letter and the report from his legal people. Sorry, Councillor Tippy.
Sorry, Chair, you're making a huge assumption that we're all of that mind. Not everybody has spoken. I'm really finding that a little bit difficult to understand.
Well, A, it's not necessary for everyone to have spoken, and I am not saying yay or nay. I'm saying, would the committee be happy for this to be deferred for additional information that some members seem to be wanting to be provided? Obviously, if there's no second, or there's no seconder for that, it's not going to be deferred, and we'll move to the vote. But I say it's not for every member to speak. You have to assume that members who've kept their own counsel have been listening and made up their own minds. It's not necessary to speak, and so we could go either way. We can still go to the vote on the officer's recommendation, or we could go to deferral. I just thought there were sufficient queries that have been raised by people who don't seem to think they have enough information. But no, I'll happily go with the feeling of the room if I try to assess it right, but I may have got it wrong. Councillor Barnes.
Chairman, I would rather refuse than defer.
That put me in my place, didn't it? Right, okay, so, no, that's fine. So, yes, Councillor.
Yeah, I think because you were wise enough to re-invite Mr. Brown back, I think the matter of the judicial review has been clarified in my mind that there is, the court saw sufficient grounds that all of these are considered items and would be considered, not as it was presented, that it had been completely quashed. So that's no longer a question hanging over it for me. If the medical information is of such a confidential nature, I'm not particularly comfortable with it, because I think everything rests, or considerable weight rests on medical and educational needs, and it's just a couple of lines saying we think it's okay. I'm not comfortable 100% with that. I'm not sure a deferment, though, would address that. So I'm happy to consider, go to a vote.
Thank you. I could claim that my work is done, because at least it promoted a discussion and it's kicked the idea out. So at least my work is done here. Okay, so I can go home, can I? So are there any more points, any more questions, or is someone going to move something? Councillor Graham.
Sorry, one more point. I would just like to say, in unsavoury remarks, I think, are probably not the best phrased attempts at just saying that this is not an application for a pitch. This is an application on a piece of land, and I think that was the point being made. I don't think we should lose too much. Deviate from that too.
Thank you for that. Someone going to propose something? I suppose I should do it first, I suppose. Can someone move accepting the officer's recommendation, please? And that will set us clearly on a course of action, whether we accept it or not. Can anyone propose accepting the officer's recommendation, please? Well, I'm going to move, and hope someone will second, the officer's recommendation to accept it, please. Because the answer then is to...
You have a seconder, Chairman.
I'm waiting to see it, but the answer, of course, then is that if the mood is to not accept it, we know exactly where we are, and then we've got time to work on another motion that gives the reasons why. Rather than coming up with like we have in the past, notwithstanding the officer's recommendations, blah, 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 I'm seeking to have a clarity on the officer's recommendation to either accept it or not, and then if we don't accept it, then we're into a new ball game, as it were. So I'm moving accepting, and Councillor Timpey is seconding the motion to accept the officer's recommendation.
Can that be made subject to the thing about the size of caravans? Condition as to size of caravans?
One moment, I think.
Can I just check that those there are conditions in relation to size, particularly condition 9 and condition 10. And I wonder if condition 9 addresses the point in particular.
Well, not really, because as defined within the Caravan Sites and Control of Development Act 1960 and 1968, it could be up to 20 metres long and proportionately wide and high. And I don't think that's what the applicant's really asking for, nor should we grant.
Can I say, I think last time we specified the maximum size, didn't we?
We did. I mean, that can be delegated to officers as to the precise measurements, but approximately what's there now.
But of course, the application is only granted if we look at condition 2. The block plans are already set out, and it's only those block plans and the location plan that are permitted.
They've got the size of them. I thought the block plan did have the size of caravan. Matthew.
Yeah, thank you. On the temporary permission that was granted last year, members did impose an additional condition, the 11th condition, and it was worded, any static caravans present on the site shall not exceed the dimensions annotated on the approved block plan. And it was given the reference, the reason being to protect the High Weald national landscape. So I believe that's the condition Councillor Mair would like adding.
I would be content with that, yes.
Councillor Gray.
Can I just check the timescale? Are we saying to 26 or to 27?
I'm just coming to that one as well now. The officer's recommendation, and obviously it's in the conditions, is to 30th of May 2027. So that would be another reason, if you don't think it should be that, it would be a reason for voting against the officer's recommendation. Because you or put an amendment to it to make it back to June 26. So, Councillor Barnes.
I just raise something else, and that is, if this is approved, the site is restricted only to the two ladies and their dependents. This is another problem with not knowing the age of the dependents, because in the past we have had Caravan A and Caravan B, and then suddenly we are getting requests for those dependents to live in a caravan alongside the given applicant. I must say there is just so much now that we're talking about that I am totally and utterly. I really am worried about the future of this, because we have made no stipulations about how the site will be emptied before they're moving on. We have absolutely no evidence from officers that we will ever find another site. This could go on in perpetuity. We could find ourselves in this area of AONB, which we're all the way through this report, it's peppered with references to how important it is that we don't mistreat this site. And here we are looking at all sorts of, well, it might be all right if we do this or we do that. It's not all right. It's not all right. We should not be even thinking about this. We must consider the ramifications of what will happen if we give permission to those two ladies and their dependents.
The only comment I would make there is that your first one's about future applications are future applications. They're not for us to concern ourselves with now.
Chairman, in the past, it has always been that when we have a site given to people of gypsy and traveller status, that it's the door open for dependents then to come and live on the site, partly because they must come and live with an ailing grandfather or whatever it is. It goes on.
But a future, I say, we're not concerned with the future application now. That would have to be a future application, I know, and is in danger of coming back to the
This is going to become a site, Chairman. There's no doubt about it if we are not careful.
I'm loath to say it. Councillor Ganley.
I have to agree with Councillor Barnes. Without stipulating the number of caravans allowed on the site, you leave the door open to the descendants of the two ladies to put another caravan or 2 or 3 on the site.
It's condition 9.
Condition
it very clearly limits the ability to have
2 pitches. Indeed.
2 pitches with no more than 2 caravans on each pitch.
No more than 2 caravans on each pitch. So that's 4 caravans.
Yeah.
So this would authorise 4 caravans to be installed on this site. All the more reason to refuse it, I would say.
In fact, condition 9 doesn't stipulate 4, and I'm just looking to the officers for clarification, but so it says there shall be no more than 2 pitches within the site, full stop. On each of the 2 pitches hereby approved, no more than 2 caravans shall be stationed at any one time. Absolutely.
One moment, Councillor.
Of which no more than 1 shall be a mobile home or a static caravan as defined under the Acts. So,
I think this was put in, and I'll come back to Matt and Kemi. This was put in originally to allow for mobile caravans for family to visit. So there were 2 permanent mobile homes as per the site plan, and then the ability for touring caravans, no more than 2 to attend. Is that correct?
And if you look at the block plan that's been approved in the permission, so in condition 2, you see that there's provision for 2 40 by 20 mobile homes on each pitch. That's on the block plan.
That is part of the condition 1, that it would be as shown on the condition 11 last time had it as shown on the block plan with the date of the block plan. So obviously this would have a similar.
I'm just bringing up the reference. The block plan is 2022-1321 version 1-prop block. The date of the plan is 4th of October 2022. There's only 2 block plans on the application, and this one clarifies that the mobile homes may be 40 by 20, and that also on the site there is parking for 2 vehicles, one of which may be a touring caravan. So that you could have a mobile home, a touring caravan, and 2 cars. That's the maximum you can have associated with a pitch. That's right. So a mobile home, a touring caravan, and 2 cars, or 2 vehicles. So each pitch. So a maximum of 2 mobile homes, 2 touring caravans, and 4 cars.
Matt is just trying to bring
That's
up
the block plan that's relevant.
the block plan. So the 2 black blocks there are the mobile homes, and then towards the woodland, between them and the meadow that's on there, where those arrows are pointed, it's parking for 2 vehicles and 1 touring caravan. And that was obviously what was approved last time as well, so that it was with the touring caravans.
So what is proposed for approval is 4 caravans and 4 cars. 4 cars.
No.
2 mobile homes and 2 touring caravans. That's the maximum.
What a name you want to give to them. is fine with me.
No, the application is for a residential use of the land. The mobile homes give you the residential use. The touring caravans are there surely allowing, because of the personal characteristics of the people, is to allow visitors who are likely to bring a touring caravan with them. That is not supposedly permanent. It says parking for 2 vehicles and 1 touring caravan.
Yeah.
The residential application is for the 2 mobile homes, and then the site includes the parking and touring caravans. Councillor Barnes.
Chairman, 832 on page 13 is very clear indeed about what will not be allowed when making up our mind about planning permission for G&T and site allocation. Well, if you look at 1, 2 and 3, the site is not located in a nature conservation designated area. It is. The site should not result in an unacceptable visual or landscape impact. It will be, particularly if we are adding more caravans. The site is located within or close to an existing settlement. It is not. There is no way we should be considering this as a site either permanent or temporary for this particular use.
Any other comments before I move to the vote specifically on accepting or rejecting the officer's recommendation? With the additional conditions, the amended conditions, and the amended condition that was circulated yesterday by Trish Triggle. So the motion is, in line with the officer's recommendation, to grant temporary planning permission. Those in favour of the officer's recommendation, please show clearly and leave your hands up long enough for them to be counted. That's 5. Sorry, clearly. Those against accepting the officer's recommendation, please show clearly. And those, any abstentions? So the officer's recommendation is carried with those amendments to the conditions to grant temporary planning permission. Thank you. I now intend calling a break for 15 minutes for members to make their way to the members' room. Please do not discuss upcoming applications. There is coffee in there. I say 15 minutes. Thank you. Who?
That one. Who? You're short of one, aren't you?
No, Councillor Gordon.
I'm going to show.
Excuse me. Oh, that's right. Councillor Delaney will do that for you. Save your legs.
Chair. Cake was lush. Thank you very much.
He's such a good.
Yeah, 10.
Thank you. Right, the webcast has started again, and we move to agenda item 8, which is application RR 2024-233P, which is Capria, Cottage Lane, Westfield. The proposal is for a dwelling house attached to Capria, And the officer presenting this, again, is Matthew Worsley. Matt, please.
Thank you, Chair. The site comprises the side, rear and front garden of Capria, which is a semi-detached dwelling located on the corner of Cottage Lane and Parkview Road. The site is within the development boundary for Westfield, as defined within the Development and Site Allocations Local Plan, is within an archaeological notification area and is also within the High Weald National Landscape. The proposal is to subdivide the plot and construct a two-storey dwelling attached to the northern side of Capria, as indicated on the plan before you. The proposed dwelling would mirror the appearance of Capria, with a small front lean-to and half dormers at first floor level. The new dwelling would be a 3-bedroom, 4-person unit. In comparison to Capria, it would have a 2.96 metre deep flat roof extension which projects from the rear elevation of the dwelling. In terms of history of the site, a lawful development certificate was granted earlier this year for a proposed drop curb and vehicular access with permeable block paving parking area to serve the existing single dwelling. As the site is within the development boundary for Westfield, there is no objection to the principle of development of the site for residential purposes. The main issues to consider include the impact of the proposal on the character and appearance of the area, the impact on neighbouring properties, together with highway and pedestrian safety. So the plan before you is from the lawful development certificate that was approved. It shows the existing dwelling Capria, the side garden where there's a shed, and the existing access and parking area, together with the drop curb across the front and the parking area. The plan on the screen now shows the proposed dwelling attached to Capria, the same parking area out the front, but the existing to the side stopped up. The proposed dwelling is of a conventional design, similar to existing properties nearby, and so it would integrate satisfactorily with the host dwelling. While the existing semi-detached property would change to a terrace property, the site lies within a built-up residential area with a variety of dwellings, which, although are not terrace buildings, are all of varying design and size. Therefore, the development would not unduly look out of place in the street scene. The area that would be developed is already residential garden, not public open space, and would not be out of character with its surroundings. Whilst hard standing and parked vehicles would be present across the majority of the frontage of the two properties, it is important to consider that this could be provided under the LDC Lawful Development Certificate granted earlier this year, whether or not the current scheme is granted permission. In terms of the impact on the neighbouring properties, the development has been assessed as not having an unacceptable loss of light, overshadowing, being overbearing, or creating unacceptable levels of overlooking. The application proposal offers off-street parking for 2 cars for both the existing dwelling and the proposed dwelling, and is very similar to that granted under the Lawful Development Certificate. From an officer point of view, there are no highway or pedestrian safety concerns. On the subject of highway safety, you will have seen the update that was circulated with information regarding the highways licence and comments from the County Council in that regard. They advised that should planning permission be granted, a new licence would need to be permitted for the 2 dwellings, so the existing licence wouldn't apply. In summary, the site is within the development boundary of Westfield. There is therefore no objection in principle to the development or subdivision of the site for a new dwelling. In line with both local policy and government guidance, the provision of a new dwelling on this site is considered to represent an acceptable and sustainable use of the land, which would have a satisfactory impact on the environment and neighbouring residential amenities. For the reasons explained, the application is supported at officer level, and the recommendation is to grant planning permission subject to conditions. Thank you.
Thank you, Matt. We now move to the public speaking section of the meeting. We have one registered speaker on this agenda, and that's the Clerk to Westfield Parish Council, Jane Clark. I'd like to make way forward, thank you. You have up to 5 minutes to address the committee based on your previous written submissions. You're not allowed to introduce anything new at this stage of proceedings, and I think you normally want a warning after 4 minutes, don't you? Yeah, I'll try and give you a warning after 4 minutes. Thank you.
Thank you, members. The Parish Council has raised concerns about this licence given to the double drop curb and looked into the matter. We then discovered that, and it has been confirmed by the Network Assurance Manager, that the permission is only for one property. In his email, he hoped all councillors which have seen, the licence application only referred to a single property, and this is the first time the case officer has seen the attached plan for the 2 properties. The crossing will only be able to accommodate 3 vehicles, not 4 as shown on the plan, in order that they park at the correct angle. As you can see from the map that is on site, I'm not really sure how that 4th car is actually supposed to get out of the proposed development because there is not the space for it to turn. The crossing is just for Caparia 1 property. If the change of use is confirmed, this will require separate application. This means that the proposed application does not meet highway zone criteria, which clearly states the parking space must be at a right angle to the highway with the vehicle able to enter and exit the property in one movement. This is not achievable at the moment. Therefore, the proposal before you can only accommodate 1 car parking space. This is not sufficient parking for a 3-bedroom, 4-person dwelling, and the proposed car parking layout cannot be achieved. Whilst the Parish Council accepts the complete removal of the garden and grassed area for space of a driveway as permitted development, the squeezing in of a secondary property in this area is an overdevelopment of the site and significantly changes the overall appearance of the area. As stated in a similar application which went to appeal and was dismissed in Northiam, the Planning Inspectorate stated that development in comparison to neighbouring development along Station Road, the proposal would extend across most of the plot and therefore be cramped on the space available. This arrangement would erode the sense of spaciousness that characterises the wider area. The same can be said for this site. This area is made up of single and semi-detached dwellings. These semi-detached and detached properties allow clear green gaps and spaces and is also within their AONB and reflects the local rural setting, whereas this proposed development is terrace style, creates an urban and closed-off look in style and character more akin to a built-up area in Hastings, and is rather contrary to Rother's proposed green to the core local plan. The officer states that this is in a built-up residential area, but fails to note that this is in a rural setting down an unclassified road, but he has noted that none of the surrounding buildings are terrace in style. The nearby Parkview Road, with its newer built properties, are all semi-detached to replicate the surrounding character of the area. Any terrace properties within Westfield are, as far as I'm aware, not located in this area and were built before the AONB designation. Therefore, the character of the area will be significantly detracted from, contrary to policy OSS4 of the Rothes local plan. Also, merely mimicking the existing buildings does not show high design, and the design merely mirrors the adjoining property, as you cannot fit a detached, well-designed property on the site, which again is contrary to policy EN3. It is also not compliant with policy DGH9 of the DASA, which expects the development not to detract from the character and appearance of the wider street scene. In a recent meeting, it was noted that whilst this will not set precedent, it will create a new normal, allowing other properties to develop out into terrace properties along the lane, further urbanising the rural unclassified lane in the AONB, more akin to development in built-up areas. On balance, the lack of high design, the overdevelopment of the site, the significant impact and urbanising of the area contrary to aforementioned policies, the lack of on-site car parking spaces, and the fact that the licence from highways is only for one, not two properties, the Parish Council feels on balance the minimal addition this development would give to Rothes housing numbers versus the objections listed asks that this development is refused or, at a minimum, deferred until clarity in relation to the licence for the drop curb is resubmitted for two properties to highways, especially as the current licence does not meet highways' own criteria for 4 car parking spaces and is for one property.
I couldn't give you a minute warning because you didn't take a breath. And you've obviously got it off to a fine art, and I didn't want to interrupt your flow, but you ended with 20 seconds to spare, which is why I didn't interrupt you. Any questions for Jane Clark, please? No? Thank you, Jane. Right, the matter is open now for questions to... Sorry, one moment. Sorry, I was just thinking. Sorry, Councillor Maynard. Councillor Maynard, the ward councillor who also called this in. Councillor Maynard.
Thank you very much indeed, Chairman. I will keep the camera off because I've got children running in and out of the room here, so I'm sure you'll forgive me for that. Can I first redeclare my personal interest as an executive member of East Sussex County Council, and I'm going to refer to East Sussex County Council in my presentation to you today. So just to say initially that I concur with the comments made by Westfield Parish Clerk and indeed by local residents that have made representations to myself. I certainly think that, and I can hark back because I can remember it when I first joined Rothes District Council back in 1999. It was then one of the projects of the then Rothes Homes, when we took on the Rothes Homes took on the housing stock and Rothes had councillors that were directors. We were extremely proud of the design within the rural setting of Parkview Road and indeed Cottage Lane. You really have to admire the fact that these were at the time and indeed still now very well designed properties for those that needed them. It was and is something that I think we can be very proud of. That said, any additions to those properties, obviously extensions, etc., have to be carefully monitored. And what we've got in front of us today is an additional dwelling. I do think that what's proposed is urban in nature. And I do think that we have to remember that this is within the rural setting, and indeed any additions and indeed additional properties need to be very, very carefully considered. The fact that the front gardens are being turned into what can only be described as a car park in a very exposed position on the corner of Parkview Road and Cottage Lane has to be borne in mind. And my view is that this should be refused. I would go on to add, as has already been said, but I would just like to amplify that I think that the issues around the permissions from East Sussex County Council regarding the entry and exit from the property in terms of the number of vehicles and whether it is indeed meeting the policies of East Sussex County Council needs to be carefully considered before surely any permission can be given, if indeed members of the committee were minded to grant permission. But I think that we have to safeguard, and indeed our new local plan is very clear on that, and our existing local plan is very clear on protections within the rural area. It is my belief that what's proposed does have significant damage and harm to the rural area. And indeed, in that particular position, I think will look very stark, especially when one considers not only the addition of a dwelling, but the treatment of the front garden, which is no longer a nice, pleasant green front garden with a parking space. What is proposed is clearly something that resembles a car park at the front of the property. And for me, that's just not appropriate and is, without question, there is no argument here, it will be urban in its design at the front of the property proposed and indeed the existing property. And I think that is to the detriment of the local amenity and the setting within the rural area. Thank you very much, Chairman.
Thank you, Councillor Maynard. We now move to questions of the office. Councillor Groner.
Oh, sorry, I was just going to move for deferment based on the highways decision or pending decision.
One moment. Kemi wants to say something before we move to that.
Yeah, I mean, thank you, Chairman. In terms of the dropped curb, they've already approved a vehicle crossing in terms of the width. That width of the highway, that width of the vehicle access also enables for the house on the side. So if you're looking at that in terms of what highways have said, they're not going to refuse it because there's essentially a new house being built on the side. They're going to be looking at it in terms of their regulations, in terms of the width of the access itself, being able to accommodate or being able to allow safe and exit, exit and ingress onto the land itself. And they haven't raised objection to that. They haven't raised objection to the number of parking spaces as well. So I will be a bit concerned as to why this will be deferred for that. Thank you, Chairman.
Thank you. On that, though, is there a seconder for Councillor Groner's motion to defer? Councillor Ganley. Did you want to say anything, Councillor Ganley, or are you just seconding? Okay. Yeah, no, okay. Before I put that to the vote, I think it's appropriate if there's any more members who want to ask questions of the officer on this occasion, but of the officer, yes. Councillor Mear.
Yes, I've seen the site. I was driving past on my way back from London, so I have seen it. On the adjacent road, on the what might be the verge on the plan there is a tree, a maple of some sort. It's an attractive tree, and I just wanted to ensure that was not threatened by this development. I think it might be outside the red line.
Is that the one within the site on the corner of Parkview Road
yes.
and the application? It looks like it's within the application site. So, to my knowledge, I don't believe that tree is protected by TPO or by it being in a conservation area. So they could take that tree away tomorrow.
And we could impose a condition that it be preserved.
Sorry? About the trees. I believe there's a condition about the trees, but it will be difficult for us to ask for trees that are not protected by TPO to be retained on site if they can take it down without consent.
Yes.
Just to confirm that the existing parking is, I think, to the side where the new house is. This and the clerk said it, and I think Councillor Maynard said it as well, this proposal is to pave over a substantial area of green lawn immediately in front of the windows of the properties. Is that right? Well, I think it is.
I mean, that is what they've got permitted development to carry out at the moment, because there isn't any condition removing their permitted development, right? So they can pave that front garden without a need for planning permission.
Yes. Yet this is the application that's in front of us. We're not dealing with somebody acting under permitted development rights. We're dealing with somebody making an application, and it's because of the application that they want to pave over the front. I don't suppose for a moment they'd dream of doing it otherwise.
I mean, they have got a lawful development certificate to pave the front without the new house on the side. So we can go on I think this is an opportunity for members. If you think that the front of that property can be improved by either adding conditions, because if this went to appeal, the inspector would take account of what they can do under permitted development. Thank you, Chairman.
Well, this is, if I may just say, this is the problem that I don't see how it can be improved. That's the only possible place to put the car parking. If that house is built, the proper place for the parking is removed.
No, I was just going to say that you could improve that by either the materials or details of materials, or coming up with ways to actually maybe increase the planting around the site or anything. I mean, this is usually, I mean, my experience is when we have new residential developments like this, we remove PD rights for a reason, because members want to protect certain characteristics within that area. In this particular case, that is not the situation. PD rights have not been removed. If you look up and down the street, there are quite a vast amount of heads office in some of the properties in the area as well, be it a single dwelling house or in this case, they are looking to subdivide the plot itself. But on some of the properties, you can see they have kept, be it just a small area of grass, but there are substantial areas of hat standing. Thank you, Chairman.
Sorry, Chair, but this is the problem with not having a site visit. In fact, I don't think there are any examples of car parking in front of the front windows of the properties. They've all got space to the side, even if it is forward of the house. They're all spacious and all not in front of the living room windows.
Sorry, thank you. Any other questions of the officer? Obviously, it doesn't stop. If the move is to defer it wouldn't stop future questions. So I just want to clarify with Councillor Groner the wording of deferring and the reason for deferring, so that we get that clearly. It is.
I think highways are inconclusive. I think we would pay attention to highways, so I think we should defer until highway have considered access to the property or granting the licence to access to the property based on 4 vehicles and not 1.
Right, I've got
something like that.
Well, what I've just written down myself and I can tinker with it was the motion is to defer the application to allow for clarification of the East Sussex Highways view of the crossing. But I know there's a problem with that because we can't control East Sussex Highways. You've already granted it. I might grant it again, so over to Kemi.
I mean, the issue I have, I mean, the problem with that is highways have written within their own representation that they have no immediate concerns to that vehicle crossover being there, regardless whether it's for one house or 2 dwellings. I mean, in my experience, highways have the limit in terms of the width of the maximum width you can go on a residential property, and whether or not you are going to that maximum width in your application when you apply for it. And it's up to the highways officers to go investigate and see whether or not that can be carried out. And in this sense, they have agreed that that can be carried out. And whether or not you defer for further clarification from them is still going to be the same. So what will members do differently if highways came back with the same comment? Thank you, Chairman.
Thank you. Councillor Graham.
Sorry, I probably should have asked this question earlier of the clerk, as she seems to have most of the details on this. Would it be possible, Mr. Chair, to ask a further question?
Okay. No. Councillor Lear.
Yes, it was something which arose out of what the clerk said, that the clerk indicated that highways concerns wouldn't be limited to the width of the crossing itself, and the point which Kemi has made, but also to the lack of space to manoeuvre cars on the forecourt when it is built. The two being able to move in and out in one movement rather than several.
Kemi, I was just amending.
The only thing I can say to that is there is no clear objection from the highways that they cannot put four car parks in that in the front of that property. There is no highway objection to this application on parking grounds or highway safety grounds.
Councillor Gray.
If it is deferred, do you think we could do a site visit?
I see no reason why we couldn't, although I have to say on this one, I think Google Maps and other map things are available online, but Google Maps is very clear of how it is. I mean, I'm just going to make my own point here, and it's really hard to, because it's within the development boundary, so our policies allow infill. But making back to Councillor Maynard, that estate was built with 15 houses, not 16 houses. It was built with 15 in 1999, and that space, presumably, don't know why, was deliberately left there with the side driveway to the existing house Capria, which left the front as a garden. I mean, there are alternatives. You could put that house somewhere if you really wanted another house. But I've got this real problem with it's destroying the nature of the area. But they're allowed, lawful development says they can do what they've done to the front, which they could do without building this house. But I've got a real problem with that because, of course, we do allow infill within development boundaries, and this is clearly within the development boundary. So that's what I'm wrestling with at the moment. Kemi.
I think there is a danger here because when the original permission was granted, it wasn't said that there shouldn't be any further extension or addition to properties on that or within that estate. You can put a two-storey side extension, which will have similar impact. So essentially, you're saying no development at all. You can have a single-storey side extension, which will take a little bit, which will take most of that width away as well. So if you're saying that no development at all will be permitted on this side, then that is essentially what you're saying by saying that the gap was left for a reason.
I said I was having problems. You may have just solved those problems. Councillor Barnes.
Chairman, policy, according to the Westfield Clerk, policy DGH9 of the DASA expects development not to detract from the character and appearance of the wider street scene. And I think that absolutely sums it up. You know, I think it will spoil it. The street scene, that is.
Right. I'm going to put the motion to vote once I've agreed with Councillor Groner again what the deferment, the reason for the deferment is. So I've got the motion is to defer the application to allow for clarification of the East Sussex Highways view of the access to and use of the parking area in the front.
Correct, because I think that would be material.
I'm just going to take advice that we're wrong
Sorry, can we add site visit to that as well, please, Mr. Chair?
One moment. The advice that I've just been given, which I can see the sense of, is to defer it for a highways reason when Councillor Barnes has just talked about basically overdevelopment of the street scene, and that's also the point I raised. They're not addressed by the deferment. They will still apply next time, even if we defer it. So I'm not sure if there's a point to deferring, and we should rather either grant or refuse. But that's me thinking. Councillor Grundy.
Yeah, just in a matter of procedure, I'd be happy to go straight to a vote on yes or no. But then, if it is yes, then move for a deferment. Because
I'm sure you can't do that, because that doesn't sound right.
Because it takes into account...
I know what you mean.
Yeah, it takes into account that part of it. And my deferment suggestion was really not, because the nature of the development's not going to change, but the opinion of a statutory consultee may.
I think that's called having your cake and eating it.
I am very much pro cake and pro eating of cake. Thank you.
One moment. So I've now had the legal voice saying, you can't do that.
You can't get your yes and then defer. You can only defer prior to a yes or no. So at this stage, so we do then need to defer, and that's been seconded, or that would need to be withdrawn in order for it to go to a yes or no vote.
I'm easy either way. You can either withdraw or I'll take a vote on deferment. It's up to you.
Please proceed, Mr. Chair, with the vote on deferment.
Thank you. Without the reason, though. What, to the committee would be lovely, yes. It's like hearing voices up here. And so one of the voices is going to explain the position on this one. Thank you.
So the concern is just that there's more than one issue being expressed. One issue is the concern about the drop curb, the parking, the manoeuvrability, and whether East Sussex County Council have really given a decision that concerns the complete extent of the plan. So that would be a sound reason for deferral, because East Sussex could then clarify whether they understand the application to be addressing the two properties and whether they're satisfied on the manoeuvrability and so on. That's a deferral reason where we could have additional information from East Sussex which would clarify that point. But, and we like a big but, this is the big but in this occasion, if the committee is actually minded to refuse the application because of an overdevelopment, then it begs the question, why defer the application for clarification from East Sussex if the committee seeks to refuse this application for entirely different overdevelopment reasons?
Which is exactly what I was pushing for before and was advised that I could not. So what you're actually doing is agreeing that we should go first and then we can go to...
Either go to deferral, but the committee's just asked to consider that you could defer, you could get clarification from Ms Sussex, but then you may wish to refuse anyway in relation to the overdevelopment. There's nothing stopping you doing that. It's just if it's overwhelmingly likely that you are going to refuse, regardless of clarification, then it begs the question what the point of deferring is. That's
Absolutely. So should we have a pre-vote?
I think we are in agreement.
The trouble with that is I thought I'd sort of assessed the feeling of the committee in the last one and got it wrong. And you can't tell if there's an overwhelming feeling until you actually have the vote. And then the horse has gone, sort of. So I think I've got to go to the deferment, and those who perhaps, who don't want to refer, vote against it and then vote for refusal. But Councillor Byrne.
Thank you, Chair. I'd like to make a comment on the subject of overdevelopment and just point out, because I've been familiar with exactly this sort of application in another life, in another place. But if you look at the location of this property, the corner location of this property, the size of their plot is such that you could not have a similar development on any of the other corners, and certainly not on any of those that are in a straight line. And it's not unusual to see a line of houses at the end of which someone has taken advantage of the access to two sides of their property to add a property or an extension or whatever. So I think that's something we would end up debating, but I just felt it was reasonable to point out to other members that this just would not in any way set a precedent because of the unique location of this property. Thank you.
Thank you. As I explained to members when we were training in that last meeting, I intended to do what I did on the last one, is if I feel it's going one way or the other, I will put the officer's recommendation to the vote first. But of course, we're constrained by what motion got moved first, and deferment got moved first. So I will... Councillor Maynard, I've just got to check. That's a legacy hand you've got up on screen, isn't it?
No, it's not, but I'm not sure, Chairman, if it's in order for me to raise a point of clarification. Your call.
Yeah, go on then. You're the ward member.
As far as I understand it, the County Council have approved the access for one property, not two.
That, I think, is what Councillor Groner also understands to be the case, which is why he's moving for deferment, for clarification on their view of two dwellings, 4 parking spaces, 1 driveway, etc. So thank you for that, Councillor Maynard. So I'm going to move the motion to defer for the reasons that Felicity said, which sounded so much better than the ones I was saying. So we'll have to go back at the recording and have a look. So the motion is to defer to allow for clarification from East Sussex Highways, full stop. So all those in favour of deferment, please show clearly, wave your hand, be seen. Those against deferment? Any abstentions? I think so. 3 is, we've got the counting wrong. Okay. That is carried, that is deferred to allow for those further inquiries at the East Sussex Highways. Thank you. Yeah, and the fact Oh yes, sorry, and it will be on a future site visit because the request was made, so we will put it on a future site visit. Not a tea break, not a coffee break. Does anyone need a comfort break? Sorry, Councillor Ganley, I love that use of the word we have been known to carry on for a bit longer. Right, agenda item 9, application RR 2024-379P, 29 Seabourn Road, Bexhill. The proposal is for a variation of conditions opposed by RR 2021-1234P to allow for design and layout amendments to narrow the dwellings and avoid excess digging in order to obtain a natural England licence. I'm going to redeclare being a member of Bexhill Town Council.
Redeclare.
Councillor Timpey, thank you, and Councillor Byrne, thank you. The officer presenting this one is Michael Vladno. If you please, Michael.
Thank you, Chair. So good afternoon, councillors. If any of my presentation needs repeated, please let me know. I've got quite a broad accent, so if you don't understand anything, just let me know. This application relates to 29 Seabourn Road, as shown on the site location plan and Google Earth imagery, and seeks permission to vary conditions of the recently approved application, RR 2021-1234P, which, as the Chair said, is to allow for design and layout amendments to narrow the dwellings and provide a better habitat for ecological species residing at the site, namely badgers. This application is a Section 73 application, and as such, it does not reconsider the principle of development, but is only concerned with the proposed variations to the previous approval of 2021. For members' context, this application follows on from two recently approved applications, RR 2020-2132P, which obtained permission from members for the demolition of the existing bungalow and detached garage and construction of a terrace of 3 houses. A subsequent application was approved under delegated powers, RR 2021-1234P, which is shown on the next slide, which obtained permission for the demolition of the existing dwelling and construction of 3 detached family homes, parking and access to Seabourn Road. As you can see from the slide, that is the site plan as approved under the previous application, 1234, and the next slide shows what is proposed under this application. So as you can see, the dwellings have been moved slightly further towards the road, and they have been reduced in width by 0.3 metres, and their height has also been reduced, as well as amendments to the rear gardens, which I'll get on to in a minute. So the main issues regarding the consideration of this application are considered to be the impact on the character and appearance of the area, the effect on wildlife, the effect on the amenity of neighbouring properties, and foul and surface water drainage. Regarding character and appearance, as mentioned before, the principle of providing 3 detached dwellings has already been established by the accident permission. The dwellings would appear as chalet-style bungalows, which should be seen in the next couple slides, and would be in keeping with the surrounding buildings and aligned with the ridge heights along Seabourn Road and Bishop's Walk, which range from 6 metres to 7 metres. As you can see, that is the elevations as proposed. Plots 2 and 3, as mentioned previously, would be moved further to the south when compared to the previously approved scheme. However, they would still be set well back from the roadside by at least 8.3 metres, ensuring that they have a similar impact to that already approved. The dwellings have also been reduced in width by 0.3 metres, which further reduces their bulk and scale when compared to the previously approved scheme. A proportionate amount of front and rear garden space would be retained for parking and amenity purposes, both of which meets the required minimum standards, and the distances retained between the boundaries of the plots and flank walls would be consistent with the layout and arrangement of properties in the street scene. As you can see from the next slide, it should be a side elevation of it, what it would look like, and that's as proposed. Regarding wildlife, the variation proposes that the Badger corridor that runs along the western side of Plot 1 is amended to be a width of 1 metre and 2 metre width from fence to boundary wall and 1.33 metres from fence to post and rail. The application also proposes to alter the rear gardens to allow for a 7 metre buffer zone between the rear of the plots and the start of the residential curtilage, and this is an increase from 2 metres. As previously approved, it was 5 metres, so it's an increase from 5 to 7. Both Natural England and East Sussex County Council have reviewed the scheme as proposed, and they raise no objection and state that it will provide a better habitat for biodiversity / badgers on site. For some context, there's a couple of photos in the next slides. This is photos of the site which was taken during the consideration of the previous applications. This was a site in 2021. There should be a couple more. Matt just flicks through them. Yes, that's as the house was being demolished. Regarding impact on neighbours, the dwellings would be a shell style design and would be reduced in width by 0.3 metres when compared to previously approved, ensuring that they're not overbearing to neighbours to the west, number 2 Bishop's Walk, north to number 33 Seaburn Road to the east. Regarding the neighbour to the south, number 4 Bishop's Walk, the rear of the proposed plots would be positioned 17 minutes from the shared boundary, which is in line with the previous 2 approvals at the site. The terraces, it is noted that terraces have been proposed to the rear. The terraces are proposed to Plot 1 and Plot 3, and these have since been amended and have been brought in from the edge of the dwellings to ensure that there's no continuous bulk to the adjoining dwellings and to prevent direct overlooking. In regards to drainage, it is still proposed, foul water is still proposed to be disposed of via connection to the public sewer. This would be an agreement with Southern Water, who would agree to Section 106 agreement. With regards to surface water, a surface water scheme was approved under the previous application and was supported by East Sussex County Council. East Sussex County Council, as the lead local flood authority, have been consulted on this application and they raise no objection to it, and they feel that the proposed narrowing of the dwellings will not impact upon flood risk or surface water management design for the development. So overall, to conclude, the principle of providing free detached dwellings on the site has already been established by the extant permission. The proposed amended layout, design and reduction in scale of the dwellings would provide a betterment for ecological species on site and would have an acceptable impact on the character and appearance of the area, would meet the needs of occupiers and would not harm the amenities of neighbouring properties. As such, it is recommended that planning permission is granted, subject to reimposing / varying the relevant conditions. There should also be further photos on from this, which show the site as it is today, with works having been carried out in regards to the badger licence. So as you can see from that photo, that is the 7 metre badger / biodiversity area, which is marked at the edge there by wooden fences. So that's how it is now. If you continue on, Matt, there should be a few more photos, and that's just some of the planting that's been planted in the area. Yeah, it should be just, if you just flick through them, Matt, there should be various ones. Yeah, that's current site as it is, and as you can see, might be a little bit hard to tell from that photograph, but the small sort of posted fence that is the just sitting below the close quarters fence, that is the 1 metre badger run that would run to the west side of Plot 1, so it's 1 metre in width. Yeah. That's it. Thank you.
Thank you, Michael. We now move on to the public speaking section. We have 2 members of the public registered speakers today. Each of you've got 5 minutes, and afterwards members may wish to ask you questions. And the first speaker, please, is Catherine Allen. Oh. You're determined to mess up my script. Marion Crawley.
Good morning, everyone. I have spoken before, but I feel I must again on this much bigger and therefore even more detrimental plan. I'm very disappointed you didn't do a site visit. Around and including 29 Seabourne Road, the plots are historically restricted to one dwelling to provide space which gives privacy, a feeling of well-being and to preserve character. The original bungalow was 5.9 metres high, 10.7 wide and 7.5 deep, like its neighbours. Please compare these measurements to those of this application if you can. The car spaces are not to scale, so the second car can't get out without moving the first, creating noise to neighbours. The houses breach both front and rear building lines, and gardens were below the minimum in the DASA, but I was told it was okay, as they were broadly in line with set values. I can't pay a broadly in line amount of council tax, so why are exceptions and precedents being set for these houses? The council expect us to support them, yet now we are saying to Rother, actually, we, the existing neighbours, need your support over this detrimental development. Suddenly our worth diminishes. There's no support for existing residents. 4-bedroom houses bordering a protected wildlife area should have large gardens, particularly as they're north-facing and will suffer shade a lot of the time, encouraging the use of the furthest areas from the houses themselves, near to and disturbing the badger set. The plans mostly show just the new houses. You can't see the proximity to the existing ones. Hopefully you've sifted through previous applications and picked out what's current. Not easy with so many amendments. Of the 4 sets of plans attached to this, very few measurements are given. The width of the site is about 24 metres. The building footprint covers 21.6, over twice the width of the original bungalow. The badger corridor is 2 metres. By my calculation, that leaves about half a metre between the neighbour at number 33. I understand that paragraph 130 of the National Planning Policy Framework changed in 23 to read, a significant increase in the average density of a residential development in an existing urban area may be inappropriate if it will result in developments which are wholly out of character with the existing. 3 4-bed houses are totally out of character with the predominantly single-storey modest bungalows. That's how planning described the area for other applications, including one opposite, 29. Yet somehow exceptions are applied here with no valid reason. You're told there's no overlooking from this steep site, no overshadowing, and that overbearing is not a thing here. I ask a simple question. How can a 6.5 metre building be a mere 2 metres from another property, yet it doesn't cause a shadow? What magical properties do the walls of these new houses have? Their own windows look onto bare walls about a metre away to prevent overlooking. This proximity and the new density being created is totally out of character. Extreme harm to biodiversity has already taken place. The site has a mitigation plan. That plan was submitted with no evidence that it would work, no previous cases cited to prove its efficacy, no research studies showing any part of it had a basis for success. Natural England couldn't give me details of a single case where badgers had been restricted, such as here, and had survived. This plan hasn't worked. Section 106 states 17 slow worms must be translocated. Only 11 were found. They were a breeding colony, yet in all the destruction, not only had they not bred, but the 17 had been decimated by 35.5%. In March 2020, there were 6 badgers. Now only 1 is seen regularly, so 60% less. No cubs for the last 2 years since the interference. Committee members, Rother Council has a biodiversity commitment. Mitigation hierarchy starts with avoid harm, then minimise, mitigate, and finally compensate. No avoidance here at all, resulting in a lot of harm. Our properties are still being impacted by the lack of badger space and inadequate proofing. That needs to be addressed urgently, and certainly before any new permission should be considered, let alone granted. The presumption for development doesn't apply where there's a need to protect important areas or where adverse impacts outweigh the benefits, and in this case, they certainly do. I urge you to consider your responsibilities towards biodiversity and existing residents and to request changes to the plan and the mitigation before all is lost. Thank you.
Thank you. Thank you. Any questions for Marion Crawley, please? Councillor Gray.
Hello, Marion. Thank you very much for coming back again. I just want to double check with you about the number of badgers, because last time you came there were quite a few badgers. Did I hear you right that you said now you've only seen one?
Yes, I think most of you know I have trail cameras, and when I moved in, they were a source of delight to me that I was near badgers. And yes, in 2020, my camera picked up 6 badgers regularly. The following years, they've not had cubs, as I say, and now my camera just picks up 1, possibly 2. They are difficult to work out whether it's the same one, obviously. They look very similar.
But no cubs this year?
No cubs this year or last year.
Can I just ask, do you think there's a reason? Have they moved elsewhere or have they died?
I obviously I don't know why there's a reduction. If they have gone elsewhere, it will be because of the disturbance, because they've been there for years. Okay.
Thank you. Any other questions? Please, Councillor Ganley.
Thank you, Chairman, and thank you for your presentation again. I'm wondering what modifications you're seeking, given that planning permission has already been granted for the construction of 3 properties on the site. So I'm wondering what modification to this application you would like to see.
I think for the terrace application, the previous application referred to here, the 1, 2, 3, 4, was authorised under delegated authority, and we didn't know that was going to happen. And obviously, from the previous cases, the depth of feeling for the biodiversity on that site was overwhelming. And so for this one, I think the badger area hasn't worked. I don't think it's big enough. And I think the way, on paper, it sounds good that you've got a 7 metre by whatever it is, 22-ish, 23. Sounds good, but half of that, as came up in previous meetings, half of that they've never dug into before anyway, and if they do, they undermine the roots of the silver birches. And for that reason, when the artificial set was mooted, that was being constructed on top of the land to preserve the roots of the trees. Now, that's the only place that the badgers can actually extend the set. So what is happening and has happened, yes, our properties have been proofed. They've broken through it 3 times. And in fact, this morning I looked over the fence on my side, and they're digging very close to the fence again. Now, because they know that they've broken through the badger proofing before, I think it's a matter of time before they do again. And that is towards under my house, so that is a concern.
So you're looking for an improvement in the mitigation?
In the mitigation.
I think the badger run.
Yes.
Thank
well,
you.
the badger, my part, the badger run itself is, so you've got like a corridor and then it goes down into the bigger area at the bottom of the gardens. So the badger run is 1 metre wide, and that's been planted with hedges. So part of my concern is the management of it all. So for my area, if partly the trees that have been planted are on top of the badger set, So the roots, as they grow, okay, and overhanging and actually managing it as well is going to be difficult, because I don't think anybody's going to be able to walk down a hedged 1 metre wide boundary, 1.33, sorry.
Thank you. Any other questions? Councillor Groner.
Oh, hi there. Did I hear you say that it should have been called in, or the original?
Yes.
I'm not sure if we're talking about badges or whether we're talking about when it shouldn't have been delegated.
2021, 1, 2, 3, 4P.
There we are. So 1234P wasn't called in, partly because our ward member was told by planning, as we all were, that I think it was the water people, the drainage was in dispute, and so they were waiting for. Oh, sorry, they were waiting for further details about the drainage, but he had already said that he would be calling it in, and just the history of the site would have, ordinarily, I would have thought, been a cause to call it in any case. The Director of Place and Climate Change called it in on the previous application. It didn't need ward councillors.
Thank you.
Okay.
Any other questions? No, thank you. Thank you very much. And now, provided no one's changed the script again, it's Catherine Allen, please.
It is with surprise and sadness that I am addressing another planning application for 29 Seabourn Road. There have been 6 planning applications spread over the last 10 years. Only 1 was refused. The rest all approved with conditions, yet we still have nothing built. Please accept that I am not a mathematician, statistician in understanding scales and boundaries. The first application in 2014 was refused, cited because of the large scale with the bungalows in the area, visually intrusive position in relation to bungalows, overshadowing, loss of outlook and loss of privacy. There was a 4-metre distance between the western boundary of my property and the first build. It stated there would be good gaps to the side of the buildings and would not project beyond the rear walls. RR 2017-258PP still left a 4-metre boundary between the plot of 1 and 2 Bishop's Walk, described as a small terrace, not projecting either front or rear build line. RR 2021-1234P, new case officer, Mr. Vladinu, delegated decision, not taken to planning, suggesting Councillor Clark didn't call it in. With no regard to the history of the plot, I spoke to Mr. Clark, who informed me he had spoken about bringing it into planning and was told they were waiting a drainage report. Changed from a terrace to 4 3-bedroom houses. The original 2014 application only ever had 2 3-bedroom houses and 1-bedroom houses. Proposed previous conditions have either not been met or broken by the developer. Example, a pre-commencement condition is to ensure the existing badger population is conserved through appropriate mitigation. There were 6 badgers recorded on site in 2020. Recordings since the proofing in 2023 show between 1, possibly 2. As you're aware, this is an ongoing contentious development being discussed. The developers are on their fifth ecologist, Dan Bennett. I believe you will be informed that all investigations from the Rural Crimes Team have concluded there is no evidence to suggest further investigation is required, as no badger tunnels collapsed whilst mechanical diggers were brought onto the site on 2 occasions, the 21st of October and the 1st of November 23, resulting in a stench that no neighbour has ever smelt of a rotting, dead badger. At the time of the police investigation, the condition was the ecologist would be on site before any commencement of digging with machinery. However, on both occasions, Mr Bennett, ecologist, was not on site. Rural Crimes initially stated they would be doing a post-mortem on the body of the badger. This was never done. As Dan Bennett, ecologist, claimed no badger tunnels collapsed, so no further investigations into the badger deaths were needed. This makes a mockery of the Badger Act 1992, which highlights the importance of limited vibration and noise in the disturbance of badgers. I bring you today's proposal, RR 2024-379P. It is proposed as making more room for the badgers. How is this? The development has increased by 3 metres forward, projecting significantly over the front field line. When was it previously approved to move the build over the front line by 3 metres, increased by 2 metres at the back, projecting over the rear build line, thus in total extended by 5 metres in length, yet only 0.67 metres shade from the width? The height is increased, not previously approved at this height, or the extra 2 windows on the western boundary. The badger run from fence to rail is to be increased by 0.33 metres and 0.13 metres, where it wavers to 1.2 metres. How is this to be done to preserve existing badger proofing? Or in fact, is it broadly in keeping and won't matter? I cannot possibly condense the impact this proposed development has had on my mental health and well-being. Overshadowing, loss of light and privacy have a significant impact on a person's quality of life. I worry that I will be completely overshadowed and suffer extreme loss of light in the mornings. I live in fear my pride and joy will become hemmed-in prison. Policy OSS2 addresses the right to refusal on the effects of living conditions of the occupiers of adjoining buildings. The approach from the developers has been mercenary. I hope each committee member here has the chance to review all objections and digest them. I ask in concluding today that you do so with compassionate hearts and not with fear of being fined for not having granted a previously approved planning application in which conditions were either not met or broken.
Thank you. Thank you very much. Any questions, please? Sorry, not the public. Any members of the committee? Councillor Groner.
Yeah, I was just looking at some of the photos that were presented by the officer earlier, and the ground looks very, very high on that. I mean, I haven't been to the site because we didn't have a site visit, so.
No, so I wish you had had a site visit. I don't know why that didn't happen.
Yeah.
I turned my microphone off, I do apologise. I don't know why you didn't have a site visit. The site has changed so significantly, it's highly recognisable. I think my biggest concern, is the fact that, it's been brought 3 metres forward, which will mean I'll have no light to the side of my house whatsoever, and the huge loss of biodiversity that I can't see will ever be gained over even the next 10 years. I don't know if we can bring badgers back.
No, sorry, the question is really the height of the...
6.8 metres.
Are they all, is it all the same? Is it a flat sort of area between everything?
No,
it looks like that land is higher.
It goes down from top to bottom. And they're proposing to build, I think, plot 1 at 6.8 metres high, which will project significantly above any bungalow. Thank you.
Thank you. Councillor Mear.
You say that it will affect your side windows. Which rooms of your bungalow are affected by?
So the only light I have to my bungalow is from my conservatory, from the front room and the conservatory, is the windows around the conservatory. They're proposing to bring the build to in front, the same one forward. I don't know if someone can show you here. So I won't have any light in my front room or my dining room, and it will take all the light from my kitchen. How much more light do you want to lose? There must be a right to light somewhere.
Have we got the right pictures?
Can we bring the...
You haven't got... There's my bungalow. I believe that's my bungalow.
Have you got the plan?
No, it's not.
Have you got the plan, please, Matt?
I don't believe you've got any pictures of the bungalows next to the development, have you? I'm at 2 Bishop's Walk.
We're just getting to the back plan. We're getting to the block plan, which should...
Oh.
Keep going. Keep going. There's about 2 more. Keep going. Keep going.
Well, if there had been a site visit, you would have been able to see how much light I'm going to lose. Oh, there you go. So that actually looks like they're building on top of my house. Yeah. However, that is my conservatory at the front, and that's where they propose to put the... So they've moved it 3 metres forward. So I won't have any light to my house whatsoever.
If you sort of excuse me, yours is the house to the left of that picture.
Yes, that's correct.
Yes, and that rounded bit at the front, that's conservatory.
Yes.
So you've got light coming from the south and from the west. But
the light comes from the west, so there won't be any light till the afternoon there. So that's my light that I get in from the afternoon. That won't be blocked, but I won't get any. So I'll be in darkness in the mornings. If I'm right, I might be wrong. I'm not. I don't understand it all, but I believe, being on that boundary, the light comes up from that side in the mornings. The eastern side, sorry.
Well, so it's not like it's closed as you would because it's on the corner.
Any more questions? Councillor Timothy.
Yeah, hi. Thank you for your presentation. Could I just ask, your bungalow has no other windows other than the conservatory?
Not in the front. I've got a window a bit further down, which is my kitchen.
So you just have one window in the conservatory?
Yes.
Okay, thank you.
Thank you.
Councillor Gray.
Thank you, Catherine.
Thank you.
Just a very quick question. Are all the silver birches still there? I couldn't see them in the photos at the bottom of the garden.
The silver birches have been, what they call it, I can't think of what the technical term is, cut back. But they are there. Badger proofing has been done around them. Yes, so they are still there. Thank you.
Thank you. No more questions? Thank you. I've now got Councillors Clark and Delaney, both ward councillors. Councillor Clark, as you called it in, I'll start with you. Thank you.
Sorry. Thank you, Chairman. I called this in because I still believe that the effect on the street scene and the size of development is overdeveloped. I mean, this site has blighted my ward for 10 years. Many years it stood half demolished and was absolute eyesore. I cannot believe all this time a resolution has not been found to develop a site that is acceptable for local residents. This site has caused a lot of distress for residents that live close by. I still believe the current application is too big for the street scene. All the houses around the site, close to the site, are back from the main road with large sloping front gardens. I think, I've always said in the past, I could have accepted 2 dwellings on the site, but in my view, the current proposal overdevelops the site. And if passed, the owners who will be moving in will certainly need to get on well because they'll be very close to each other. Site plan, can I have the site plan put back up, please, of the actual site? Because, as has been mentioned by Mrs. Crawley,
which one? The
site plan. Yeah, it shows the. I mean, that gives a very good example of the size of the proposed site. And it dwarfs the small properties next to it. It is a massive site. And to me, that is not in character of the area and houses around it. It's a difficult one because it has had planning permissions, and I know planning officers don't like things going to appeal, there can be costs. But in the end, it's the decision of this planning committee. Then there is the issue of the badgers, which has been ongoing for some time. They have been shunted around this site to make room for these houses that will be built. They must have been caused a lot of distress by the noise and work on the site. Badgers can't speak for themselves, and they also can't read boundary signs where they're supposed to stay and where they're supposed to not go. It's quite ironic that some years ago, Orbit built social housing in my ward on Rother Land. 8 homes were deleted from development, so not to disturb known badger settlements. It appears things have moved on. I do understand the developer wants to maximise the profit on his investment. I still believe this application is not acceptable to myself and my residents. They will be highly priced dwellings that will not have local housing needs. A minor adjustment in height and width of the dwelling will still not affect the impact on the size of proposed development. Thank you for listening to me.
Thank you, Councillor Clark. Councillor Delaney. Can you turn your microphone off, please, Councillor Clark? Thank you.
Thank you, Chair. I'd just like to echo some of what Councillor Clark said. Certainly this site has been a concern for me since I've been a councillor here. And I'd like the committee to consider the following issues of overdevelopment, loss of light and privacy, the build line, and the impact on the local environment when reflecting on whether this remains an appropriate development in design and density for the site. So certainly from moving from one property that was originally there to 3 will significantly alter the character of this residential street. The density of development will be at odds with the neighbouring properties, which are similarly detached but enjoy more space between each other. In considering the development and site allocations local plan has recommendations around outside space for gardens, in that they should be in relationship to other properties in the local area, but necessarily the density of this development means that the gardens will be much smaller than any neighbouring properties. And additionally, the properties perched on the steep slope that Councillor Grona, I think, picked up on will mean that you have 3 properties significantly overlooking the neighbouring properties to the north. The properties will be approximately 2 metres from the neighbouring properties on either side, the east and west, which is quite close, much closer than other properties in the road. The highest property measures 6.5 metres, threatening to substantially overshadow the neighbouring properties and significantly restrict the amount of light that they enjoy currently. There's also concern about the side windows and the potential loss of privacy because of being overlooked in that way. In addressing the build line, the new properties will advance approximately 2 metres forward of number 33 and 4 metres beyond number 35. And this, again, will affect the character of the street. And finally, the environmental impact has been significant. There was a significant badger colony on the site, a large colony of slow worms. They've had to be removed. The badger colony is severely curtailed now. The density of the development is likely to inhibit the flora and the animal life, the badger set on the site significantly, and will certainly not represent a biodiversity net gain. It will be a big loss to the local area. So I would recommend refusal. Thank you.
Thank you, Councillor Day. Before I come to you, Councillor Timby, sorry, sir, I can't have members of the public, unless you register to speak, I can't let members of the public address. Sorry? That was, it was too late. Too late, I'm afraid. Thank you. Sorry. Councillor Timby.
Thank you, Chair. As I understand it, this has got full planning permission anyway, and these are just variations of conditions that we're considering. So the fact of overdevelopment, etc., must have already been discussed and approved. So I think we should stick to the point, what it is we're actually discussing, which is the layout amendments to narrow and to avoid excessive digging. And to meet the Natural England requirements regarding the badgers. So if we could sort of narrow the discussion to that, that would be helpful, I think.
I agree. Yeah, thank you. I was going to say myself, this square in the circle is horrible because planning has been approved for this site, irrespective of the views of anybody here. These recommendations or these amendments are sought on the advice of Natural England to make the badger position better. We're not experts in badgers. It sounds like, nor a Natural England, it sounds like the badgers have already been badly affected by this. If we refuse it today, the builder can still go, the applicants can still build to 2021 1, 2, 3, 4, which was not as favourable to the badgers. And we are just in a never-ending circle of hell, I think, because it's been approved. We cannot, unless we can think of some really good extra conditions that could really bolster up the badger protection, but that's down to Natural England. If the badgers are adversely affected, and I know somebody spoke about the rural crime team and stuff, that would be a criminal offence, and that is for Natural England to pursue, not for us. So at this point, I have to say I hate my job. Is there anybody else who wants to comment? I'm sorry, I can't speak. I can't let you speak. I'm sorry. Councillor Mear.
Can I ask the officer a question, please? Mr. Fladino, could you put the plan up again, with the houses on? Can you put the houses back on the plan? That's the one, yes. That's the approved one, and this is the one. Yes. You see the car parking there at the front. The one to the left has a little piece marked green, which I take to be grass. The other two have got teardrop-shaped things. They're not marked green. What are they?
Yeah, I believe they're grass verges as well. I just don't think they've been marked green on the plans, but I do believe they are grass verges as well. So they would be the same as plot one. I think they're all three are grass verges, yeah. They just haven't been marked as green on that plan. Bearing in mind what was said on the previous application, I think you were here to hear it,
Has County Council Highways expressed a view on the car parking arrangements there?
They wouldn't make comments on the application. They've just referred to their guidance on residential development and the measurements, so being set back from the road and the space. It does meet their requirements. It has been set back far enough for cars to get in and out, and it does meet the space standards. So they haven't provided any formal comments on any of the applications that I'm aware of, but they've referred to their supplementary guidance, which I've measured, and it meets those standards. So yeah, they haven't provided any sort of formal.
I think the guidance includes all sorts of things. You can't say there's a straight yes and a straight no, but it includes softening materials such as low hedges and things of that sort. I don't think there's any room there for low hedges to break up the sight line of the parked cars, is there? No, there can't be. No. Thank you. I'll come back to that later, Chair, if I may.
Councillor Gamley.
Thank you, Chairman. Michael, I'd be very interested to know what the 45-degree line test consists of. I can guess, but I'd prefer it to be accurate.
Yep, so the 45-degree line test is a tool we use in planning regarding light. So what you would do is you would take a measurement from the centre of the window. So from the neighbour's window on number 33, you would take a measurement from the centre of that window, essentially, and 45 degrees outwards. This sort of. So if that's the window's here, and you would take 45 degrees from the centre of that window, so it would be outwards, and the development would not be forward of that 45-degree line. Yes, does that explain what it is? Yeah, so that's essentially what it is. That's just a rule that we would use for determining applications.
Thank you very much. Thank you. Any other questions? Any other councillors wish to speak or move anything? Councillor Mear.
Yes, Chair. I have tremendous sympathy with the residents here. I was a member of the committee which granted the original 3, which was a terrace designed to look like one building, but 3, and was an attractive building. I'm not quite sure exactly why that one couldn't be built. We then have the next planning application, which was decided under delegated authority. That's 2021-1234 for 3 exceptionally unattractive detached houses, which now seems can't be built because of the badgers. And we have the now amended plan for the slightly different chalet-type bungalows. But what we do have here is what came up on the previous application, is the question of parking in front of windows. Now, I have to say that I don't think there's anything that I'm going to say which is sufficient to refuse this application, because the principle was established under the delegated authority of this type of building. And I'm sorry to say that, and I really do feel for the local councillors and for the local residents. But we really must establish in this authority good design, good urban design. It's all there in the National Planning Policy guidance, and we should put it into practice. I mean, the fine words are there, but so often we do not actually carry it through into practice when we come to approve these plans. Now, so far as parking in front of houses is concerned, it's interesting that the draft Regulation 18 new local plan does have something to say about this. Now, I'm going to be told by the lawyer that we can only place very limited weight on this, if any at all. But there was always the straw that broke the camel's back, wasn't there? Now, in curtilage parking, where in curtilage parking for individual houses is to be used, car spaces must be to the side of the main building and at least 5.5 metres behind the building's front edge to prevent the vehicle protruding. In curtilage parking in front of narrow-fronted properties should be avoided if better alternatives are available, and where unavoidable, must be restricted to 2 adjoining properties to reduce the visual impact of parked vehicles on the street scene. So we are making that, and that is firming up, going beyond what is in the existing DASA. And I think perhaps everybody might think of commenting in the response to the consultation on this, because we are cheapening and demeaning our street scenes in an attractive town, in an attractive location, and we really shouldn't be doing this. We should be drawing a line and seeking good design in keeping with the existing, while at the same time trying to provide the houses that we need. And I think the original design here was far, far better than we have ended up with. As I say, I don't think it's enough for me to vote against this. I don't think sadly, we have arrived at this point, but my sympathies really do lie elsewhere. Thank you.
I have to say I agree with that. It's quite sad, actually. But just to echo your 2 points, yes, we probably can't put any weight whatsoever on what's going to come up in the local plan, but you've echoed my please, everyone, take part in the consultation of the local plan and make sure things like this are covered, that we don't have parking outside houses and windows and things. Councillor Mary Barnes.
Just to say, Chairman, how much I agree with what Councillor Mear has just said, but also to express yet again my sorrow that the Town Council doesn't express an opinion. Yeah. Do they not have a planning subcommittee? They would have been so useful on this particular occasion.
Reminding you of my previously declared interest, I cannot possibly comment on the Bexhill Town Planning Committee. There is a planning committee, and that's where my comment ends. But yes, efforts have been made to try and improve it. Thank you.
Chairman, it was so useful to have the comments of the clerk of Westfield Parish Council. So to have that input is almost, it's just so necessary. So I wonder if pressure can be put on them to get their act together and provide us with comments.
What can I say? We're trying. I know of only one application that Bexhill Town Council came to, and that was a councillor was put up with very little support to flounder in front of this committee. But yes, thank you. I think I'll take those. I'll find some way of passing that on to the clerk, I think, for those comments. Councillor Clark, I'm not sure if I can ask you again, or if I can hear you. Go on then. Yeah. But not Councillor Delaney, just you.
Somewhat confused because...
No, thank you.
I'm somewhat confused at the planning officers accepting the reason for the calling because of my concerns of overdevelopment site and the street scene. But as been said, all that was dealt with in previous applications, so you don't have to discuss it as a committee. So what was the point of the calling then? I'm a bit confused.
I'll get you an answer to that. Not today. I'll get you an answer. Because although I'm being told it is for variations, and what you've called it in for are planning considerations,
yes.
It's just the rest of us think we're in a cleft stick and can't do anything about it. But yeah, I'll let Kemi, because she's getting very frustrated with what I'm saying. Kemi.
No, thank you, Chair. It's just the call-in says that you should, if you want to call an application in, just give planning grounds. It doesn't say it has to be appropriate. It just says planning grounds. If you want us to tighten it and say you can't call this in because it's a variation, it's already been approved. We can do that, but it just says you need to give planning grounds for calling the application in. And I've already done that in, I think I did a very comprehensive response to one of your letters or emails to say what is already been considered previously, and this is just a variation, and so will not be considering all the other principles before, in this application. I've already done that. I'm not sure if it's Councillor Thomas or who sent the complaints in, and I responded to it in that sense. Thank you, Chairman.
Thank you. Councillor Gray.
Thank you. Just to be absolutely clear, if we refuse this, it goes back to the original plan, which, so, as you say, we've got a hideous choice here. So this is a slight improvement on the last one.
Well, I think the two ladies objecting would probably disagree with it being a slight. No, sorry, please. I don't think they probably agree that it's a slight improvement. Please, I don't think they would agree it's a slight improvement, but it's something. It's different because it's involved moving the House forward. I'm just going to ask Felicity to address.
Just to be the really unpopular voice in the room, so often my job, it's right that it would not be lawful for this committee to try and reconsider anything about 1, 2, 3, 4. That is done and dusted. It's a fully approved grant. All this committee can consider are the details of this application, the Section 73 application, which is just a variation. So all you can really consider is the variations that this application proposes to 1, 2, 3, 4. It's right that if you refuse this application, the developer can only revert to 1, 2, 3, 4, unless they choose to submit another fresh variation application.
Councillor Ganley.
Just say, I've just noticed that actually the development was approved 10 years ago. It's not 1, 2, 3, 4 that is the first approval. It was approved 10 years ago and not been built. I'm surprised it hasn't been. Anyway, there we go. I just thought I'd bring that to your attention. I hadn't noticed it, maybe others.
I think Councillor Clark has probably lived through every one of those years. Yeah. Yes, indeed. Right, anybody have a mind to move anything? Or shall I move acceptance of the officer's recommendation to grant variations of the conditions to allow for the design and layout amendments to narrow the dwellings and avoid excess digging? Thank you, Councillor Ganley. Right, so what I've just said, and I'll say it again. So the motion before you is to grant variation of conditions imposed by RR 2021-1234P to allow for design and layout amendments to narrow the dwellings and avoid excess digging. All those in favour, please show clear. And those against, please. And those abstaining. Thank you. That is carried and that permission is granted. Agenda item 10. Members, just to note the next date and time for future site inspections, which will be Tuesday the 25th of June, departing the Town Hall at 9:30. And the next meeting here of this committee is Thursday the 27th of June at 9:30 a.m. Just to note, we have limited time on that day because of the general election and the work that needs to be done in the Town Hall. We have to be out of here by 2 o'clock on the 27th of June. Thank you. That brings us to the end of this month's Planning Committee. Thank you. Goodbye.